Is he a senior advocate?
During this case, the principle of natural justice is violated. So far, the petitioner plaintiff is concerned,
Is he a
was
senior
not
advocate?
allowed to depose as per Annexure 8. The evidence and affidavit being violated, opposed by the defendant, plaintiff is concerned that it was not pleaded in his place. Allowed to my lord knows as per order as per Annexure 8. The evidence need not be pleaded. The evidence and
How is
affidavit
the writ appeal maintainable?
being violated, opposed by the defendant, plaintiff is concerned that it was not
How is the writ appeal maintainable? This is arising from a civil suit, right?
Yes,
How is it a writ appeal maintainable?
Evidence and provision chapter 8 rule 2 sub rule 1 by the defendant that it was not
How is it maintainable? This is arising from a civil suit, right? How is it a writ appeal maintainable?
chapter 8 letters patent sub rule 1 by the defendant, no other provision is there.
No, how is it maintainable? This is an order, interlocutory order in a civil suit against which you filed a writ petition under 226.
Final order by the refusing me to adduce evidence.
Writ petition by a single judge. This is in a matter like this arising from a civil suit. How is a writ appeal maintainable?
By the refusing me
Of course, but against the disposal of a writ petition arising out of an interlocutory order in a civil suit, how is a writ appeal maintainable?
by the refusing me
Of course, but against the disposal of a writ. Have you studied this? Have you studied the maintainability? It's a full bench judgment of this court. Appeal maintainable. It's a full bench judgment of this court. Have you studied it? Of course, but show us the disposal of a writ. Have you studied? You're saying yes. Show us the judgment. It's a full bench judgment of this court. Appeal maintainable. It's a very bench judgment of this court. Have you studied it?
Right of that,
Where is the judgment, sir? First place the judgment, then tell us. Show us the judgment. It's a full bench judgment of this court. It's a very bench judgment of this court. When asked about the maintainability of the procedure to be counsel for the appellant, first place the judgment, then tell us. Place the judgment of the judgment before the court. That is requested. It's a very bench judgment of this court. When asked about the maintainability of the procedure to be counsel for the appellant, first place the judgment, then tell us. Judgment of the judgment before the court. There is a judgment of this court. When asked about the maintainability of the procedure to be counsel for the appellant, first place the judgment, then tell us. In the contempt case, you say the appeal having been dismissed, the order be implemented.
It's a second contempt, Your Lordship.
Item
It's a
3.
second contempt.
Yeah, but the impugned order be of the single judge be implemented forthwith. All right.
3 also same.
Item 3.
Same. All right.
Item number 4.
My lord, item 4, 8, 9, and 13. All these matters, Your Lordship, have already dismissed the WA number 488 of 2017.
Okay.
Since
In
this
view of the
age
dismissal of writ
relaxation
appeal number
matter.
488 of 2017 by the order dated
1810, Your Lordship.
1810
1810.
2022. These appeals are dismissed. All right. 4. Which are the 4 numbers?
My lord, that is item number 4, 8, 9, and 13.
All right.
Item number 5.
Because I have filed a memo for withdrawal of the writ appeal.
All right. The memo is taken on record. The appeal is dismissed as withdrawn. All right.
Item number 6.
May I please, Your Lordship? My lord, both the petitioners are mechanical degree engineers, my lord, and the petition number 1 is a scheduled caste candidate and petition number 2 is a OBC candidate, my lord. Both the petitioners were continuing as in the post of non-executive under Coal India, my lord. They were asked to appear a written test for the promotional post from non-executive to executive, and they faced the written test. In the written test, they qualified, and also subsequently in the interview, my lord, in the Viva test, both the petitioners secured more marks than the selected candidates. In the Viva, my lord, even if they have secured more marks in the Viva test, the petitioners were not selected, whereas the candidates securing less marks than the present petitioners have been selected, my lord. And also on this score, my lord, 2 points were framed by the honorable judge. Your Lordship may kindly see. the impugned judgment, your lordship may kindly see. At page 41, your lordship may kindly see. Well, since the present two petitioners are departmental candidates, well, the viva marks should be given weightage. Well, in spite of securing high marks, then the selected candidates, the present petitioner number 1 has secured 4 marks in the viva, and the petitioner number 2 has secured 5 marks in the viva. They have not been selected. Whereas your lordship may kindly see page 41. Your lordship may kindly see. Well, the selection committee has prepared merit list of excavation discipline by taking aggregate marks of the written examination and the interview, which according to the petitioner is not proper for the reason that the selection procedure provides that a candidate is to be qualified in the written test is not worth to be seen, rather it is only on the basis of the marks obtained in the interview. The selection has to be done. The petition number 1 has secured 4 marks and the petition number 2 has secured 5 marks in the interview, while Bijendra Kumar Mahato, General Singh have secured 3 and 4 marks respectively, but even they have been selected and the engaged, as would be evident from Annexure B, annexed to the additional affidavit as flag D, my lord. Both the selected candidates admittedly have secured low marks than the present petitioners in the viva, my lord. My lord, so far as these two petitioners are departmental candidates, my lord. When they have qualified the written test, my lord, that part is over. So far as the viva, my lord, viva, they are being promoted from non-executive to executive post, my lord. They are going to the supervisory post. Therefore, the weightage should have been given to the viva marks, my lord.
How can judges come and sit and rewrite a viva marks, sir? This is something very unusual. How will the court rewrite your viva marks? Whatever committee has given you the marks, that's the marks that you've been given. Well, court comes in only when the procedure is not properly followed. Well, if we start interfering, saying, oh, you should get 10 marks and not 5 marks, that man should get 11 marks and not 3 marks.
Well, second
court
point
cannot do all that, sir. Definitely not in the viva OC.
Well, at second point, your lordship may kindly consider at the page 41, your lordship may kindly see reservation policy has not been followed as per model roster of reservation annexed as annexure A to the additional affidavit is at flag D, whereby and whereunder total 16 vacancies have been advertised to be filled up in excavation discipline, for which written test was held on 25/5/97, and as per the reservation roster, out of 16 vacancies, 4 vacancies ought to have been filled up from OBC category, but from Annexure B, annexed to the additional affidavit, it would be evident that none of the candidates have been appointed under OBC category, getting the benefit of relaxation reservation policy roster appointment. Here, my lord, reservation policy has not been followed, and no relaxation has been given to the present petitioners. And also, this aspect of the petition matter, my lord, was not taken into by the consideration by the honorable single judge. Your lordship may kindly see. Thereafter, my lord, while summarizing the grounds,
in the promotional post is a reservation.
My lord, your lordship may kindly consider these petitioners were called to face the interview against the direct recruitment post reserved for the direct recruitment quota, my lord. That is the admitted case. Against the post reserved for the direct recruitment quota, my lord, these petitioners have been called for to face this election, my lord. And also this court directed to produce the relevant record whether the relaxation policy has been taken into consideration by the department. That was not produced. For non-production of the record before this honorable court, my lord, the honorable judge has passed order. The honorable judge will not get into that aspect of the matter. You will also may kindly see that at page 42, the honorable single judge has also passed that order.
In the absence of any material particulars, what is that?
My lord, that the relaxation policy, what has been given by the opposite parties, that was not, in spite of the direction from this honorable court, the record was not produced. No affidavit has been filed. You will also may kindly see page 41. Your Lordship, in the meantime, almost 1 year has passed.
No, you've already appeared in the subsequent selection process in 2000. This was the selection process of 94 and 97.
97, my lord.
But subsequent selection process, you had participated.
No, my lord, the petitioners did not participate. That challenging that selection process, the petitioners approved the son of the court.
No. Just come to para 6.
Yes, my lord, the 2000, my lord, the Viva test was conducted. Thereafter, my lord,
How can you question the 94 process, sir, after you appear in the 2000 process?
my lord, what has happened in this case? 94, there was the petitioners were called to that face the selection process, that was cancelled. And 96 also they were called to face the interview, that was also cancelled. Only in 97 it was allowed to subsist, and the petitioners appeared the selection process, and they also qualified in the written test. And thereafter they also faced the interview and secured more marks than the selected candidates.
That was in 97.
Yes, my lord.
But in 2000, when this process was repeated, you participated.
No, in 2000, my lord, 2000, I did not participate. My lord, in 2000, your lordship may kindly say, I have annexed that, annexure, my lord, the advertisement I have annexed. From open market, my lord, the candidates were invited. My lord, at page 19, my lord. That was the advertisement inviting applications from freshers from the open market. In 2000, my lord, that was the finding given by the honorable judge, my lord. In 2000, I faced both the petitioners faced the interview, Viva test. Viva test, both the petitioners faced, my lord.
So you filed the writ petition only in 2002.
Yes, my lord.
You're agreed by a non-selection of 1997.
Yes, my lord.
What were you doing for 5 years?
My lord, no, my lord. In 2000, my lord, when interview was, Viva was conducted in 2000.
Sir, 1997,
yes, my
Viva was conducted. You got some marks. You say you should have got more marks. That challenge you raised only in 2002.
My lord,
after participating in the subsequent selection of 2000.
Well, 2000 is the Viva test, my lord, not relating to that written test in 97, held in 97, my lord.
They held a Viva after 5 years. Cannot be.
After 3 years.
3 years. No. How can it be? For 3 years, they didn't hold a Viva.
My lord, yes, my lord.
No. That's why that para 16, you're not properly reading. That's not correct. What you're saying is not correct, sir. Just come to para 6. Petitioners appearing in the subsequent test. You appeared in 1997. You were not successful. You again appeared in 2000. Not successful. 2002, you filed writ petition. Now you're saying I should have been selected in 1997.
No, my lord. In 2000, my lord, the present petitioners have not appeared, my lord.
Then you file a review petition, sir. The whole single judge says you appeared.
My lord, your lordship may kindly give some time. I will look into the 2000. No. Lord, admittedly, my lord, the present petitioners have not appeared in 2002, my lord.
Then you have to file a review petition, sir.
My lord, your lordship may only grant 1 day, my lord. I will look into the matter.
No.
1 day, my lord. Tomorrow it may come, my lord.
No.
Tomorrow.
You will pass it over. Whatever you want to find out, you find.
Yes, your lordship may pass it over.
Pass it.
Item number 7.
None appears dismissed. The memo is taken and record. No instructions dismissed.
Item number 10.
Lord, state is the appellant. There is a delay of 290 days, but
let it be on delay. The delay is not properly explained.
my lord, this should not be treated as a precedent because a valuable piece
Nevertheless,
of
the impugned order will not be treated as a precedent. All right.
Item 11.
None appears dismissed.
Item number 12.
Please, please, and this is a case, my lord, 6 days delay. Lord, your lordship come to the merit of the case. In case your lordship find, Lord, what has happened? Initially, they said 4 years, the period you have not completed, you are not eligible. Then they said you have not qualified, you have not secured the cut-off marks. The order has been passed. I have filed a petition. Your lordship kindly come to this page 77. That is the petition I have filed for calling for records that marks secured since they have disputed that I have not come to the cut-off marks. Initially, what they have said, I am not eligible. And the rule, your lordship, rule position, my lord, the entire selection process, page 92, your lordship kindly come to the page 92, that I have quoted, page 92, that the rejection slip, in order to ensure transparency in the recruitment, in case any candidate is eliminated at any stage, he will be issued with a rejection slip with the format as prescribed in
Which item are you appearing in, sir?
12 mark.
Savitri Prasad.
15. I'm sorry.
That's why I was wondering what you're arguing.
12. Item 12. No.
None appears dismissed.
Item number 14.
None appears dismissed.
Item 15, sir. Item 15.
Yes, ma'am. Sorry, ma'am.
Item 14.
Sorry.
14. Sir.
14.
Item 14.
14.
Relief.
My lord, the petitioner has already explained the delay of condon, but inadvertently the certificate for the medical report is not filed. I will file in course of the day, or your lordship may, the delay is, I have explained my delay of condon, and the certificate is with me that has not been annexed, my lord. That is the only.
Sure, sir.
Petitioner is at the age of now 72, my lord.
No, being under treatment is one thing, not being able to even move and instruct is, you're not immobile, sir. This does not say you're immobile.
My lord, in paragraph 2, I have explained why the present petitioner is not filing in time, my lord. Will kindly delay the condon, and my lord, there is also the point of the case is involved, my lord. The Honorable Single Judge has in twofold that has been rejected the present writ petition. One is the natural justice is one fold, and another fold is the competency of the authority. In respect to the, my lord, if your lordship may kindly glance into this. Yes, my lord, if your lordship kindly glance to the writ petitions page, my lord, where Annexure 8 series is itself reflect that those documents is sought for by the petitioner, and that has not been supplied, which they have admitted in their counter, my lord. And another fact, my lord, if your lordship may kindly glance to the inquiry report, where it is specifically stated that I want to draw the kind attention, Annexure 8 series, which are sought for, and in the counter, my lord, at page that only few documents, my lord, at 101 of the running file, in the counter of the opposite party, only few documents which could not be readily retrieved from old records of the branch could not be produced to the defense. Of these few documents which could not be made available to the defense has harped on the production of only the field of registers. Thereafter, my lord, if your lordship may kindly glance to the inquiry report, my lord, itself at page 27 to 60. I want to draw the relevant portions of the field, my lord. Page 30, my lord. It could have been an inadmissible document in this court. Anyway, I cannot take cognizance of there since it was expunged document. Under the circumstances, PO could have been cross-examined MW3 declaring him hostile. The deposition of MW3 was contradicted to his own reporting.
Please, my lord is getting what page you are referring to.
My lord.
What page you are referring to?
My lord, running page 30, my lord, of the writ petition.
They scanned the wrong petition. 23746, is it?
7546.
7546. Where do you get this? No, the scanned petition is 7546. Correct. Yes. What page? 7546?
My lord,
You're referring to the inquiry report now.
My lord, now inquiry report. Before that, I have already referred the counter where they have admitted they have not given certain documents in their counter, and thereafter, my lord, inquiry report itself reveals that how the defense at page 30 and 31, my lord. The relevant person at 31, my lord, benefit of doubt will not pass to defend that. Here we cannot come to the, my lord, may I read from 30?
Yes.
My lord. At middle of the, anyway, I cannot take cognizance of the letter since it was expunged document. Under the circumstances, PO could have been cross-examined MW3, declaring him hostile. The deposition of MW3 was contradictory to his own reporting. Apparently, it looks that he was a hostile witness. Presenting officer has failed to declare him as hostile and cross-examine him to elicit the truth. Defense assistant has also pointed out why the presenting officer has not elicited the truth from MW3. Similarly, the defense assistant reliance on field inspection, that is, oblique field visit register, was not made available to them deliberately by the presenting officer, is also not in a good taste. First, the defense should understand that the presenting officer cannot be expected to arrange for the defense document. Since the CSO was placed under suspension and he cannot be allowed free access to the record of the branch, they have to request the inquiry authority for verification of the records and document. The inquiry authority will direct the custodian of the document to allow the defense to go through the document and to provide the copy of the identified document. The defense cannot itself for a copy of the document which was not available. If it
What
is
is
not
the charge? It's not clear. What is the charge against you?
My lord, charge is at
Absenting from duties without prior sanction of leave. That's the charge.
My lord, I have already explained in the review that has been quoted.
What is the punishment awarded?
My lord, terminate kar dijiye.
That is one issue. The purchase of goods and equipment without bills. Availed of an unauthorized SR advance of 15,000 towards PL LFC encashment. Yeah. 3,000 is credited to Zone SB account for purchase of dress materials. What are IRDP beneficiaries? Wow. Going on and on. So how many charges against you? 15.
My lord, may I please annex 10 of the writ petition, page 92 to 97, only the page 95, where the details of the contention of the petitioners is already reflected by the reviewing authority, my lord.
16 charges, sir, against you. I have asked you a question. Now I have found the answer myself.
My lord.
You did not hear the question, so you did not answer. My question to you is how many charges against you?
My lord.
There are 16 charges against you.
My lord. May I place only for the moment, your lordship may pass. Just at page 95, my lord,
Yes.
of the writ petition.
All right.
My lord, Sri R.K. Bear has submitted his representation dated 1/6/2007 for review of the punishment imposed. In his representation dated 1/6/2007, Sri R.K. Bear has stated that, number one, that the order of inquiry officer dated 16/12/2004, order of the penalty dated 9/4/2005, and order of the appellate authority dated 26/4/2007 are illegal, arbitrary, and against the settled principles of inquiry not being conducted in accordance with the provision of the service rules, and therefore the impugned orders are liable to be set aside and he is to be exonerated of the charges. Number two, the order of the suspension was issued by the zonal manager, who was the DA, but the charge sheet was issued by the assistant general manager, who is ranked below than the zonal manager. And the issuance of the charge sheet itself is without power, authority, and jurisdiction, and hence the word and amnesty and entire inquiry is liable to set it. There has been gross violation of the principles of natural justice, and he was never afforded with reasonable opportunity of hearing in this case. He has specifically asked for supply of documents by letter dated 1/11/2002, but the management did not supply the relevant documents which are highly essential for defense of the delinquent. Despite recording non-supply of documents to the delinquent, the inquiry officer proceeded ahead with the inquiry and concluded the same, which is violative of the principles of natural justice and against the settled principles of law. Thus, the inquiry has been conducted in a perfectory manner. First, the inquiry officer, my lord, was appointed after almost 2 years, and he conducted the proceeding to a substantial extent, and suddenly the inquiry officer was changed and replaced by one Mr. Selvaraja. Abrupt change of inquiry officer was fatal to the defense of the delinquent. The second inquiry officer belongs to the vigilance wings and bore a conviction mind from the inception itself. He even did not record the facts stated by the defense assistant. The second inquiry officer, having official bias, proceeded in erroneous manner and conducted the inquiry in perfected manner. Inquiry officer, though issued notices to 9 persons to be examined in inquiry, deliberately 4 vital witnesses were not examined by him. And had these persons been examined, the defense could have been finalized, falsified the illegal and erroneous charges. The inquiry officers acted in a contravention on Rule 6 of Service Rules, and the inquiry is vitiated being illegal, arbitrary, erroneous, and contradictory. The biased inquiry officer, after making a perfectory inquiry, straightway concluded the inquiry without recording the defense. Thus, the delinquent was not given sufficient reasonable opportunity of hearing before inquiry, during the inquiry, and also after the inquiry. Despite the order of inquiry officer, the field infection register was never produced, and had register been produced, the factum of the 2 details of the delinquent would have been well proved. The charge number 6, 7, 11, and 13 has not been proved, and charge number 1, 5, 30, 1, 5, and 16 have been marked as partly proved. Charge number 1 has been erroneously framed without application of judicial mind. As per the orders of the RO, Bhubaneswar, salary was recovered from a total period of 9 days, which was intimated to him. Once the department has recovered salary, the delinquent can never be punished for the same allegation in the impugned order. Therefore, the charge number 1 is redundant, being erroneous. The disciplinary authority did not issue any show-cause notice with the proposed penalty, and the delinquent has not been given reasonable opportunity of hearing before imposing the major penalty of the removal from service. Charge number 2 is not conclusively established. The borrowers were never produced to prove the factum of non-delivery of the full loan amount. Some borrowers, even though noticed, were never produced for examination and cross-examination. The department has tried to punish the petitioner by any means without following the mandatory procedures. Charge number 3 is vague, illegal, and erroneous. By letter number 1611 to 199, he was given permission to avail LFC by Zonal Jedo, Calcutta, and he made withdrawal of rupees 15,000 from SRII and availed the same. And subsequent adjustment of the same does not reveal any misconduct. None of the borrowers were examined to prove the allegation in relation to loan. On the one hand, the charges has not been conclusively established in the inquiry. Inquiry is conducted in a perfunctory manner. The vital witnesses who could have thrown light on the alleged were withheld. The allegation raised in the impugned charge sheet do not reveal a misconduct on the part of the delinquent. The allegation in the charge sheet reveals only practical niceties, which impugned order of major penalty is grossly disproportionate and liable to be set aside. He is now at the age of 56 years, and during his service career, he has never been punished for any kind of delinquency. He is the sole breadwinner. These are the complaint.
All right. Dismiss both on the ground of delay and merits. We'll pass the detailed order. All right.
Item number 15.
I may be pardoned, my lord. Item number 6 that was passed over, maybe taken up. Item number 6, ma'am.
Yes.
Maybe taken up, madam. Item number 6 may be taken up, madam.
Yes.
Yes, madam. Your lordship may kindly see the page 37 of the impugned judgment, my lord.
Yes.
My lord, it is stated that in the year 94, there was a call for holding interview for the promotional post of Executive 1 from the departmental candidates possessing the qualification engineering degree, mechanical, electrical. It is claimed by the petitioners that the both of them were selected in the said interview, and but reason unknown to the petitioners, the interview was cancelled. For the same post, another interview was conducted in the year 95. Petitioners though called to attend the interview, but the interview was cancelled. Finally, on 25/5/97, a written test was again held for the promotion to the post of Executive 1. Both the petitioners participated in the said interview. Upon receipt of biodata of eligible candidates, as per their communication dated 17/5/97, the interview was to take place on 25/5/97. The petitioners claimed that in the interview dated 25/5/97, both of them remained qualified and their names appeared amongst 44 candidates selected in the written test. There was no further development pursuant to such interview, and in the meantime, by virtue of a communication of the Chief General Manager Personnel dated 6/9/2000, the VC, DC, and CR ratings in respect of eligible candidates was collected, and eligible candidates were also advised to appear in the interview on 16/9/2009. The written test held in the 97, but there was some delay till the holding of Viva in 2012, my lord, because of the non-sending of the CR ratings in respect of the present candidates, my lord.
So you waited till 2002 to challenge this 1997 selection. So the question still remains, why did you wait till 2002?
My lord, in 2000, my lord, 2001, my lord, when there was an advertisement, these petitioners were empaneled, and when they were waiting for their regret letter, if they have not been selected in the for the post, well, in 2001, there was an advertisement inviting applications from the freshers. That challenging that advertisement, the present petitioners approached.
Come to para 6. Come to para 6.
Yes, ma'am. My lord, now considering the other aspect involving the matter, considering the rival contentions of the parties and material produced in establishing their respective case through written writ petition, the counter, the rejoinder, the additional affidavit of the opposite parties, and additional affidavit to the counter by the petitioners, this court finds the allegation so far it relates to non-selection of the petitioner in the interview process taking place in the year 94 as well as 97 for the petitioners appearing in the subsequent test held in the 2000 without opposing abandonment of the previous selection process. This
Just stop there, sir.
Yes, ma'am.
This is the second time I'm asking you a question on this sentence.
Yes, ma'am.
You are not still answering.
Yes, ma'am.
You participated in the selection in 2000.
2000, my lord, I participated the Viva test, which commenced in 97.
No.
Yes, my lord, that is the case, my lord. It has also been discussed by the Honorable Single Judge in para 37, my lord.
Yes. There is no para 37 anyway.
Page 37. Page 2 of the impugned judgment and page 37.
Yes.
Of the running page.
Yes.
That has been discussed by the Honorable Single Judge.
That the interview took place in 97 itself.
Interview means, my lord, the written test.
Please, sir, you yourself read that interview took place in 97, not only written test. Please read it carefully.
Yes, my lord. My lord, that has been...
the petitioners claimed that in the interview dated 25/5/97, both of them remained qualified.
Yes, my lord.
Why are you misleading the court?
No, my lord, I'm not misleading.
Yes, you just now said that the interview took place in 2000. The interview took place in 97.
In interview, my lord, Viva test took place in 2007. 2000. 97
no one says, please, that is not what is said here. That is not what is said here.
My lord,
interview means Viva. Interview means what? Is it not Viva?
My lord.
Interview means Viva.
Yes, my lord.
Interview took place on 25/5/97.
Here might be the Honorable Single Judge has...
As per their communication dated 17/97 was to take place on 25/5/97.
No. He's trying to say the interview took place only in 2000. Where do we get that?
My Well, here that has been given finding with regard to the interview by the Honorable Single Judge, my lord. Interview, your lordship, is absolutely correct. Interview means viva. But here, interview that has been referred by the Honorable Single Judge, my lord, this interview is viva. Only it has given meaning to the viva so far as the term interview is concerned, my lord. The interview, written test and viva, two parts, the Honorable Single Judge has that has referred to the date to the year 2000 that was conducted in respect of the viva.
That is not there anywhere, sir. Nowhere in the judgment of the single judge does he say written test took place in 97 and interview took place in 2000. I don't know where you're getting this fact.
Yes, my lord. Your lordship may kindly see, finally on 25/5/97, a written test was again held for the promotion. This was the written test. In 97, it was held. And subsequently in 2000, for that written test, viva was conducted. In 2000, my lord.
You go if you want to file a review. These are not the facts on which the single judge has decided. We are unable to agree with you, sir.
Your lordship may give liberty to file the...
Yeah. Counsel with the petitioner seeks leave to withdraw this writ appeal to file a review petition before the single judge. Disposed of is withdrawn with liberty spread for it.
Weekly list item number 15.
May I please, ma'am? Lord, this is a case, my lord. Lord, impugn road is annexed A/6. Annexed 6. Lord, what has happened in the case? 6 days.
Yes.
Well, initially, the department said that I am not eligible, not completed the tenure for exam. And thereafter, they said that you have not qualified, as not secured the cut of marks. I have filed a petition in the writ petition, my lord. In this case, I have filed that calling for records, and the records should be called for. And in case I don't find any, I am not coming with the marks, then my case should be dismissed. There they have not, court has not passed any orders and disposed of with the order that I have not secured the cut of marks. The entire rule, your lordship, kindly come to this page 92, my lord. 92, my entire selection process was conducted. Page 92, if your lordship kindly come to the rejection slip. In order to ensure the transparency of the recruitment, in any case, the candidate is eliminated at any stage, he will be issued with a rejection slip on the format as prescribed, showing the rejection of the candidate duly signed by the member or chairman of the recruitment board. The slip will be prepared in duplicate. One will be kept in the board, signed in the candidate as a token of acknowledgement. Absolutely, during this selection process, they have not, I have not received any communication, nor in the signboard there was any.
Not got the cutoff marks. What is
not the cutoff, because then
the cutoff mark was 270. You got 260. You were not selected.
Sorry.
How could the single judge have said you should be selected? You didn't get the cutoff mark.
No. The order, your lordship, what I am respectfully submitting, my lord, I have filed a petition for calling for the records. The entire the rule says that countersigned by the chairman that should be that only I have prayed for calling for the records.
No.
In case there it will, I will not find the it will not be found.
Disbelieve. When somebody says an affidavit that you scored only 260, we're not going to disbelieve that.
Well, the documents what they have signed actually.
The present appeal is directed against the judgment dated 26th March 2019, passed by the learned single judge, dismissing the petitioner's writ petition, which had been filed seeking the consequential benefits of a judgment dated 4th August 2017, passed in writ petition civil 8666 of 2011. Full stop. Petitioner claimed that he had been selected in the LDCE 2005 for the appointment as sub-inspector (EXE) along with his colleagues, and therefore he also had to get all the benefits that were granted to them in the aforementioned writ petition paragraph. In the reply filed to the writ petition before the learned single judge, the central government informed the court that although the petitioner had appeared, petitioner / appellant had appeared at each and every stage of the recruitment process, he failed to secure the minimum cutoff marks, that is 270 out of 600. Also, he had scored only 260 marks. Paragraph. Counsel for the appellant insists that unless the record was produced, the learned single judge could not have proceeded on the above basis. Full stop. The court is unable to agree. An affidavit filed by the central government for the single judge was obviously based on the records. The appellant is unable to show that his marks in the selection process was any different from what is stated in the affidavit. Consequently, the court is not inclined to interfere. The appeal is dismissed.
Weekly list item number 16.
The opposite parties.
Item 16.
I am appearing for the private respondent, my lord.
All right.
This matter has become infectious.
All right.
Item number 17.
None appears for the appellant dismissed.
Item number 18.
None appears for the appellant dismissed.
Fresh admission item number 19.
19, I am appealing for the opposite party.
All right. None appears for the petitioner dismissed.
Item number 20. Item 20.
The old list.
Pass over.
Item number 21.
I am before bylaws challenging order passed in first appellate authority as the GST tribunal has been constituted as per section 109. Similar matters, my lords, have been admitting and protecting the petitioners on payment of certain amount.
But nothing seems to have happened. This matter was filed in 2021, sir.
Yes, Lordship.
In your case, nothing seems to have happened.
In my
didn't even get it listed, this writ petition. So nothing urgent. So we can't pass the similar order, sir.
Against the
notice, that's all.
Against the order of the first
interim, there will be no interim order, sir. Just say notice.
Yes, notice.
On both the writ petition and the IA. List on 3rd January.
Lordship, in this order that I am just...
He accepts notice for...
Your Lordship, for...
on payment of Lordship...
There's no need for that, sir. This is a 2021 matter. Nothing has happened to you, clearly.
Both the opposite parties, 1, 2.
Only for 2, right? 1 and 2.
Both 1 and 2.
Reply be filed within 4 weeks. Rejoinder for the next day. 3rd January. That's it.
Lordship, item 20.
Simply notice on stay. Yeah.
Item 22.
Lordship, item 20. Is it passed over, your Lordship?
Yes.
Item 22.
Lordship, item note 22. I am praying for adjournment for 1 month.
What reason, sir?
My senior advocate is not there in city. He will argue the matter.
It's only a demand notice, sir.
Yes.
Yes. Why should we interfere at the stage of notice? And that impugned order is an appealable one.
Your Lordship.
It's an appealable one.
Your Lordship. And order is also on 30th March 2021.
Yeah. There are 2 prayers in the present petition. One is a challenge to an order dated 30th March 2021, issued by opposite party number 3. That is the CT and GST officer. Who stopped. The order is clearly an appealable one, and the court therefore sees no reason why it should interfere. So as far as the consequential demand notice, without challenging the impugned order, the question of challenging only the demand notice does not arise. Consequently, leaving it to the appellant, to the petitioner, to avail of the statutory remedy available to the petitioner in accordance with law, the court declines to interfere in the presented petition, and it is disposed of as such. Yes.
Item 23.
May I please? Item 23 minutes. I am giving a small short note, my lord. Here is the case, my lord. As per annexure 2, there was as per annexure 2 order passed under section 73 of the OGST Act. Prior to that order, a so-called notice has been issued
under Annexure 1, page 10, my lord. In that so cause notice, it has been reflected in third paragraph. It appears that you have made payment of tax, interest, and penalty by debiting from your credit ledger and partly by debiting from your cash ledger in contravention of provisions enumerated under subsection 2 of section 41, subsection 3 of section 49. Read with the sub rule 85 of the OGST rule 2017. Here in the case, I have not.
What were you doing all this time?
That is the period under COVID period, my lord. Notice in the COVID period and order has passed in the COVID period.
No,
So
no. What were you doing? Not filing a writ petition for so long. You're challenging an order dated, annexed dated 22nd July 2021, raising a demand.
2207-2021 Annexure 2, my lord.
What were you doing so long, sir? You're not filed this writ petition for till when did you file this writ petition?
Writ petition filed 16 February 2022.
Simply say notice, he accepts notice.
Sir, my prayer is that, my lord, we have already paid the amount. I have nothing to pay to the department.
All right.
Department attached my bank account.
All right.
Annexure 3 is recovered to recover my entire amount, my lord. Notice and the order both are in the COVID period, my lord.
All right. Notice on the IAS.
No, let's see.
Reply be filed within 4 weeks, rejoined up to the next date. The returnable date is 22nd February. Right.
No pursuance.
Nothing like that.
Sir, bank attached.
You are not in any hurry. Yes.
Item 24.
24, 25, 26, 27. Similar matters or?
No, let's see. 24, 25, 26 are similar.
What is
But
those
only,
three?
Only one thing I want to bring you Lordship's kind attention to, page 37, your Lordships.
Of item 24.
24. Page 37.
Yes.
But already Government of India notification has protected me, saying that the limitation starts, may place a Lordships.
Yes. 3 months from the date on which the order sought to be appealed is
Yes,
communicated.
Lordships. Yes, but after passing of the appellate order, now they are threatening me to recover the amount. Just that is why I have filed this writ application, because no tribunal is there, and already Government of India has protected me, saying that this is the central.
All right. Since the second appellate tribunal is not available, the present writ petition is being entertained. Notice, he accepts notice. Reply within 4 weeks, rejoined up for the next date. Till the next date, no coercive action will be taken against the petition.
Your Lordship, subject to payment of 20%. Your Lordship,
Yeah.
your Lordship is
Subject to
passing consistently
payment of
the same
20% of the demand.
20% of the remaining amount. Besides,
remaining amount
Because
of the
because
tax.
already I have deposited the 10%.
Your Lordship, besides that 10%, another
Yeah.
20%.
Correct. Since the petitioner has already deposited 10% of the tax at the time of the first appeal, subject to the petitioner depositing a further 20%,
20% of the remaining
tax.
Your Lordship.
There no coercive action will be taken against the petitioner. When are those matters coming up?
Your Lordship,
Your Lordships already, your Lordships in the last occasion, your Lordships have passed the order saying that 10% of the remaining.
No, Lordship, but in that order, your Lordship, there is an inadvertent mistake of 10%. My learned friend, Mr. Pradhan, is appearing in that case. But your Lordship consistently saying that 20% in many cases, your Lordship. Only one case, but my learned senior also submitted in that order. In that order, only there is an inadvertent mistake that 10% to pay, since the amount of 10% has already been paid. Your Lordship, only one order. Your Lordship, but the provision is very clear that 20%. Your Lordship may kindly look.
I don't deny that provision, your Lordships. Only because of that Government of India notification is also in force till date, and my learned friend is also not denying that, because we are under this governing under this notification also. Because when there is no tribunal and Government of India is itself saying that the limitation starts from that paragraph, the start from the 6 months period shall be considered to be latter of the following, and bit 2 is the date on which the president or the state president, as the case may be, of the appellate tribunal after its constitution under section 109 enters the office. So when he will enter the office, then only my limitation period will start. But now I will pay again 20% for the no coercive action for which the state is imposing on me. Page 37, and again it was clarified by page 40, Your Lordship.
You would have to pay 20% of the remaining.
If the tribunal, but my limitation is still
I know, but
is
the
there.
point is that you are now coming here.
So
it has to be this 20% of the remaining tax, subject to payment of 20% of the remaining tax. Right.
So 24, 25, and 26.
Right. All three. We give a different returnable date then.
Your Lordship.
This was appeal. 23rd February.
Similar matter is 72, Your Lordships. But for there, they have already issued me the recovery notice. I have challenged the recovery notice itself. 72.
72.
So in that, Your Lordship, only no coercive action because I have already paid the tax. 72.
Or
already
the entire tax is
entire tax I have paid. They have not verified.
All right. In 72, you say notice counsel to petitioner claims the entire tax amount has already been paid. That's view of the matter. No further coercive steps be taken against the petitioner till the next date. Same date, 23rd February.
Oh, bless.
In item 72 also. Now 27.
Item 27.
In 27, Your Lordship, this is IT matter and my learned brother is appearing where that is clear-cut violation of natural justice, Your Lordship. Kindly have a glance at on the date of the issuance of the notice in the writ petition, the annexure number 4, Your Lordships. Annexure number 5. On 27/10, notice was issued by challenging fees. I have filed writ petition, and on the same date, order has been passed. The annexure number 6 in the IN number 14993.
So go back, Mr. Sarpati.
No,
my appeal is pending.
No, appeal is not pending. Your Lordship, see, running page 11. Yes, sorry, running page IA.
Yes, that is
running page 10. The second appeal order is dismissed.
Yes.
So thereafter the appeal, thereafter the penalty.
I have filed the restoration application.
No bar 270, Your Lordship, no. Only pendency of the appeal, first appeal or second, then only the penalty proceeding will be kept in abeyance. But the appeal has been dismissed. So therefore, it's clear, Lord, he is rightly not initiate the proceeding. And after
dismissal. When was it dismissed?
Lord, kindly see, Lord, the
my restoration application is pending before the tribunal.
Yes.
But only today my case is before Your Lordship that when 27/10 is the date of issuance of notice and the date of order is also 27/10. That is my whole grievance.
He has appeared, Lordship, he is appeared.
27/10.
Instated everything, Lord.
No, he says I received notice today. I'm in Bangalore because of my health issue.
No,
so
Your Lordship,
in the order,
come please
that is not the only notice. Your Lordship, series of notice.
Yes.
Series of notice. He has not this.
I admit, but last notice was 27/10 saying
Lordship,
that.
Running page 5 for a moment. Series of notices, not the only one notice.
Only annexure 5 and 6. Your Lordship,
yeah, asking for time and time.
Only my grievance is when notice was given saying 30 days granted for filing the appeal. Again, on the same date, they have final order was passed under the on same date, 27/10. That was received by me on 31st.
5 to 7 notices.
We could have waited for some time instead of passing it on the same day.
But there is, when
you're issuing a notice on 27/10,
yes,
granting 30 days time.
No, let's see.
Yes.
Last part.
Annexure 5 is annexure that notice dated 27/10, and you're giving 30 days time. You're not waiting for 30 days. On the same day, you're passing the penalty order.
Actually, the order.
Page 23, last line. Within 30 days of the receipt of this notice in Form 35, duly stamped. Page annexure 5, page 23. So 30 days time was granted. Annexure 5, page 23. 23. Last line.
Okay.
Notice, Mr. Sarpati accepts notice. The short ground on which the impugned notice dated 27/10/2022 and the consequential order of the same date are challenged is that despite the notice dated 27/10/2022 granting the petitioner 30 days time to comply with the demanded tax amount, to pay the demanded tax amount, the penalty order under 271(1)(c) of the Income Tax Act 1961 was passed on the same day without waiting for the expiry of 30 days. Paragraph. Mr. Satpathy in reply points out that
Lordship, Annexure 5 is a notice, demand notice under Section 156. That is not a notice. Lordship, see, Annexure 5 is a notice for demand 156 notice. But
correct.
That is
giving them 30 days time.
That is payment. That is a direction for payment of the amount. That is, yes. But order is passed to 26/7.
No, 27/10.
Yes, 27/10 order is passed. Order is attached to the 156. Or it is a demand notice. It is not a notice for appearance on 27. This is a notice 156 or no, it is a notice for payment. As for the order passed on the penalty.
Yes.
That is not notice that he has to appear on that day.
No, that is for payment.
That is for payment, Your Lordship.
But again,
pendency the appeal. The appeal is dismissed.
Yes.
But my restoration application is pending on.
That is something different.
No. Pending meaning why have you not brought that for listing? The restoration application.
Yes. It is fixed on 16th of December.
Oh, I see.
That is also clarified in page 10 on the order. Your Lordship. Therefore, it is clear. Later notice dated for the ITIT was received on the office of PCI.
No, the point is if you recover this amount, the appeal becomes infructuous.
Yes.
No, in that. That's true, my lord. That's true. But
what is the amount involved? 16 lakhs, is it?
Yes. And first appeal is lost, my lord. Second appeal is
No, because it is expiry order. It was not in my knowledge. Because of the withdrawal of the power of my learned advocate, it was dismissed ex parte and was not in my knowledge, and I have approached the authority for the certified copy, and then I have filed the restoration application and is the
and some percentage is always asked to be paid, right? This appeal is pending before CITA.
No, you'll see ITA.
ITA. Dismissed. Now he filed a restoration application.
All right. You say said that the challenging a demand notice dated 27/10/2022, as well as the penalty order of the same date. Paragraph. The grievance of the petitioner is that pending the disposal of an application filed by the petitioner for restoration of the appeal filed by the petitioner before the Income Tax Appellate Tribunal, bracket ITAT, bracket, which was apparently dismissed in default, coercive action has been taken, will stop counsel for the petitioner, informs the court the restoration application is listed for hearing before the ITAT on
16 December
2022. Paragraph. Having heard learned counsel of the parties and having perused the impugned orders, the court directs that subject to the petitioner paying 20% of the...
I may be pardoned, let's say only till 16th, I may be
whatever that will
only
continue,
16th.
that will become the interim order clearly. Even in the appeal.
Penalty proceeding.
It's all right. 20% of the demanded amount.
10%, Your Lordship. It is.
What is your individual?
No, it is actually
He's not a big person, not owner of the
No, he is not.
divisions.
He's not having anything now, Your Lordship. He is not having anything. It is his personal case.
All right, 10% of the demanded amount. No course of action will be taken till such time the ITAT passes any other appropriate interim order in the appeal after it is restored. Full stop. In this continue only till the disposal of the restoration application. Right.
Not in disposal.
Right. The writ petition is disposed of.
Okay.
In the above terms. All right.
We kill list item number 28.
28, 29, 30.
Not here the petition of 28. 29, 30 infructuous because relief has been granted.
Okay, 29 and 30 disposed
Relief
of
has
as
been
infructuous. All right, because relief is granted.
28. Here, the shop was closed as per the directive of the Honorable Supreme Court in Balu case. And the government has granted relaxation. I'm filing that, because after filing of the writ petition, that notification came. So, Lordship, as per that direction, let me dispose of that.
Counsel for the petitioner.
The government may be directed to consider his case in the light of this notification.
Yeah.
And if he is entitled to, he will get.
All right.
But
You see, the
consideration should
petitioner's
be-
case will be considered by the state government in light of the letter dated 20th November 2017. Copy of which has been placed on record with a memo by the petitioner filed today. The government will inform the petitioner of its decision upon consideration of his case in light of the above letter within a period of 8 weeks.
No, I will file an application. Lordship may say that I will file an application pursuant to that.
Or
So that
counsel, the petitioner
that will be
states that
disposed.
he will be filing an application with the government for consideration of his case in light
Within
of the
10
above
days.
letter. If he does so not later than 5th December 2022, the decision thereon will be communicated to him within 4 weeks thereafter.
Obliged.
All right.
Item 31.
The demand raised under Annex 4 has already been complied by the petitioner. That Annex 4.
Infructuous.
Counsel, the petitioner states that petition has been rendered infructuous since the demand amount has already been paid.
Under Annex 4.
Right.
Item number 32.
This is also infructuous because we have already allowed the next year to be continued.
We are seeking for a waiver, Your Lordship. The liability is still on us. That the period that the Corona period, COVID-19 period, that the notification.
This is for the entire state. We have taken a
Your
decision.
Lordship may kindly.
For any individual person, we cannot take a decision.
Your Lordship may kindly.
We have
Your
only
Lordship.
we have only said that the MGQ for this year will be shifted to the second year.
Your Lordship's
And
own order.
after the
Your
second year, if he is unable to comply, then he can come and say something. Now, not at this.
Your Lordship has passed on 1st of November similar placed matter. Your Lordship has issued notice seeking the waiver. We seek for waiver of the liability that was within when the COVID-19 period was prevailing. Your Lordship has passed this order, Your Lordship, on 1st of November.
Show me that order.
All right. Same order. 16 February. All right.
Item number 33.
None appears dismissed.
Item number 34.
The memo is taken under IA is allowed.
Withdrawal.
Yeah. The STREV is disposed of as withdrawn.
Item 35.
None appears dismissed.
Item number 36.
So item 36, a very short ground involved in this review is, my lords may kindly see page 16, my lords. Because the Honorable Court has reproduced the prayer made by the petitioner in the writ application, And your lordship may say, I was relegated to approach the authority to file reply so that a decision can be taken. At the same time, the Honorable Court has mentioned there is no illegality circular dated 1/8/2002. This is under challenge. So this I pray for expunction.
What's the point now, sir? This all must be over now. 2010, there is no stay of this order.
No stay of this order.
How can it be pending for 12 years? It won't be pending for 12 years.
So now the matters must be pending for appellate authority somewhere.
No. Now all that is due to passage of time, the petition has become infructuous, which is post of research. Yes.
I am appealing guilty.
All right.
Item number 37.
There is a matter where, my lord, a review has been filed where there was a remand, instead of open remand, my lord, they held something. In the meantime, my lord, no, I'm not on that, my lord. I'm on the fact that in the meantime, when the matter was pending and this judgment was passed, there was a judgment directly of the SEGAT, my lord, which was 3 judges, which held that small industries will not be covered by this.
That you can point that out to the appellate forums.
No, I have no appeal, my lord. Now, my lord, I cannot go on appeal.
You can't go. Even the review petition is now what? 2010 review petition. We are now answering 22.
No, my lord. I'm only saying this much, my lord. The review order, my lord, has been that I'll make a representation and they'll dispose of in accordance with law. That, my lord, unfortunately, there's an observation. Instead of being an open matter, no more SNTgram, my lord, that there cannot be open order like that, my lord.
No, it must have worked itself out, please.
No, it has not, my lord. I have not made a representation, they're not disposed of.
Then it's okay. Then that's your headache.
That
we are not interfering.
No, my lord.
We are not giving life to a 12-year-old order now.
My lord,
review petition.
No, my lord, in the meantime, my lord, by the time this order was there, my lord, it's very small amount, my lord. Very difficult for a small industry, my lord. What has happened? Very small thing, my lord. May I just tell the facts? After that, I'll leave it to my lord. My lord, here is a case where these people manufactured the cabinets for the state of Orissa's Konark television, my lord. They supplied. Konark television, my lord, took MODVAT credit for 15%, and we were eligible to 5%. And they said that no, you will definitely succeed, so you go to them. I went to them, my lord, and Konark said, my lord, Konark said specifically, they have paid, my lord. I have demonstrated also that they have paid that money. They have, in fact, MODVAT, they have taken for 15%. And I'll just show the judgment of the tribunal, my lord, which holds exactly what is available, Annex 3, my lord, which was available before the court. And that, my lord, is there's reason also for that, is also a reason for review, my lord. I'm covered by a judgment of this honorable court, my lord. My lord, may kindly see that judgment, my lord.
Mr. Das, we are now considering a review petition of 2010.
My lord, it's not
2022.
My lord,
it is always the fault of the court.
No,
we'll start with like that.
No,
I'm not fault of the court. That
I am not talking about the fault of the court.
The question really is, in 2022, are we going to review an order of what is this? Which is the date of the High Court order? What are you seeking review of? Which is the date of that order?
26/4/2008.
8.
Yes,
so you filed
2010.
All right. So you found a review of a 2010 order 12 years later. And you say whatever you had to do under the 2010 order, you never did so far. There have been no stay. There have been review petitions where we issue notice in a review and stay the order under review. There has been no stay.
No, my lord, I'm not on the stay.
No, you may not be. We are asking you what has happened.
The day my lord, Begraj Singh, my lord, is very clear. 2003, my lord, the day I come to the pursuings of the court, my right gets crystallized, my lord.
What right, sir? My lord, there is no stay granted. What right you're talking about?
No, my lord. I am only saying there was no stay necessary also, my lord. The representation was to disposed of.
All right.
My only prayer is limited, my lord. Right. My lord, now what has happened, the small industry will be saddled with a 7 lakh payment, my lord, and he'll be
now.
finished.
It all must have happened 12 years ago, sir.
No, my lord. They have not done nothing, my lord.
Stay happy, sir, if they've done nothing.
No, my lord. My lord, then, my lord,
if they've done nothing, then why are you worried?
Let this be worked out, my lord. This order, order passed by the court has to be worked out, my lord. It's not. I'm only saying that the order passed by the court has to be worked out, my lord.
All right.
My lord, may kindly read the order at page 15.
All right.
I only want that much.
All right.
My lord, may kindly read that order.
Yes.
We dispose of the writ application. I beg your pardon, my lord. I'll just show the order of the review order. Yes.
It is not annexed. It will separately.
My lord, the impugned order is at page.
Not page. Separately filed.
Separately filed. Since, my lord, at that time it was not supposed to be filed, my lord. My lord, may kindly see. 25/4/2010.
Yes.
I made
para 3
and 4, my lord.
Yes.
My lord, after hearing the counsel for the parties, Mr. Patnaik, Learned Counsel for the Excise Department, finds that the payment of the duty of the statutory liability cannot be shifted. In other words, the court cannot shift the point of review. In view of the aforesaid clear position of law, we are not inclined to direct the opposite parties to collect the central excise statutorily from the petition opposite point number 3, that's Konark. Then, my lord, 7, paragraph 7. After hearing the counsel for the parties, after going through the relevant records and the view of the point, this High Court, without expressing any opinion in regard to the prayer of the disposal, writ application, or direction that if he files a suitable application before the Central Excise authorities highlighting his grievances, the authorities are satisfied that the grievance made by the petitioner and genuine and accordance to law, it shall be open for them to pass necessary orders as per law, as per rules. That order has not been passed by them till now. That is my case. And my lord may kindly see the judgment of the SIGAT. That very point has been decided. It's no more res integra anymore. And it was there available when the first order was passed, my lord.
Right.
My lord, unfortunately, it was not pointed out, neither for the revenue nor by us. My lord may kindly see Annexure 3, my lord. Well, this is a case where they said that a branded thing, my lord, even if it's a small industry, if it is manufacturing for someone, it will be deemed to be the large industry's product. Here, my lord, I was supplying these things, my lord, my lord, may kindly see. In the light of the procedure, page 19, my lord, may kindly see. And this was available at the point of time when the writ was being heard.
Yes.
But in light of the precedent, it appeals as stated that Konark is not correct, my lord. And therefore, my lord, this in Konark television, which was the case decided, that was set aside. In the very case.
And why to withdraw this review petition and pursue your application by pointing out all this, please?
Yes, my lord, that is what I want to do.
If you withdraw it, then learned senior counsel for the petitioner seeks leave to withdraw this review petition with liberty to pursue the application already filed by the petitioner in accordance with law.
Has not been filed. I'll be filing a fresh application.
Then just say no grounds for review. I'm sorry. This is not the way.
My lord, I'm sorry. The department didn't accept.
No grounds. No grounds.
I went before the department, my lord. They didn't accept it, my lord.
No.
That's the difficulty.
Then you file a contempt.
My lord.
Then you file a contempt. You say this is not review, is not the ground. This is not, all these are not grounds for review. If somebody is disobeyed the direction given by the court, you don't file a review.
My lord, I am only saying.
The order under review asks you to file an application which will be considered by the department.
Yes.
You tell me after 12 years, you've still not filed that application.
No, my lord.
If you have filed the application and if they're not considering the application, you should file a review. It's not a ground for contempt. It's not a ground for review.
No, my lord. But my lord, when review notice was issued, my lord, they were aware of the fact that it's not an open-ended review, and that is the reason it was entertained, my lord, in the first place. And there, my lord, by that time, this judgment had come of the 3 judges. My lord, what happens? The state government or state authorities, my lord, get a benefit of 15%. And I'll have to be saddled with the 7 lakh, which is very high for me, my lord. I'm obviously, my lord, for a small industry, which is now, that business is not there. And my lord, may kindly visualize his difficulty, my lord. I will, may I just make another application, my lord? If it is...
Or Mr. Das states that he will make another application to the department and therefore seeks leave to withdraw the present review petition. Disposed of is withdrawn with liberty is prayed for. All right.
Deeply obliged.
All right.
I'm appearing.
Item 38.
I'm appearing for the opposite party.
None appeals for the petitioner.
Your Lord's judgment of 2008 has been sought to be reviewed in 2010.
All right.
Item 39.
2 week time can allow 38 because review petition.
Which matter are you talking about,
38.
sir? 38, who's for the petitioner?
Department, Central.
You tell us what it is. You're not telling us that you filed the review. 2 weeks time for what?
The file is not available in the
No.
Lord, this is the judgment of 2000.
Anyway, you say Mr. Chimanka states that file is not available with him. Full stop. The review petition is dismissed for non-prosecution. Right.
Item number 39.
39, 41 permitted to withdraw.
Dismissed.
In item number 39, I just pray that Mr. Gautam Mukherjee's name may be deleted.
All right. No, there's no name shown, sir.
No name.
In item 39, Mr. Mukherjee's name does not figure. Yes.
39, 40 and 41.
Yes.
Item 42.
Lordship, in item 38, the name of the respondent may please be indicated.
Lordship, in item 42, a very limited grievance. I'll take your Lordship to page 44, wherein the impugned order of the...
No, you didn't take steps for limitation, sir, for the last 12 years. For the last 12 years, no steps have been taken for limitation. Dismiss for non-prosecution.
Lordship, in review, the limitation difficulty is not there.
We're not providing free legal advice, sir. You find out about all these things.
Item 43.
Yes.
Item number 43. Item number 43.
None appears dismissed.
Item number 44.
None appears dismissed.
Item number 45.
This is to be withdrawn.
IA is allowed. Dismissed is withdrawn. All right.
Item number 46.
Item number 46 may be withdrawn. Lordship may withdraw it.
All right. Dismissed is withdrawn.
Item number 47.
In item 47, there is 4 years delay in file the review application.
All right. Delay of 4 years is not satisfactorily explained. The MC 113 of 2011 is dismissed. Accordingly, the review petition is dismissed.
Good. Item 48.
Item 48 has become infructuous now.
Infructuous disposed of.
Item number 49.
None appears dismissed. Defects not removed. For 11 years, defects have not been removed. Certified copy of the impugned orders are not filed. Dismissed for non-prosecution.
Item 50.
None appears dismissed.
Item 51.
Infructuous dismissed. All right.
Item 52.
None appears dismissed.
Item number 53.
No instruction. No instructions dismissed.
Item number 54.
None appears dismissed.
Item number 55.
I may be permitted to withdraw my lord.
Dismissed.
Advocacy infructuous man.
Yes. All right.
For orders item 56.
But in this matter, your lordship directed the state council to
Yes,
append
I will take some time. We'll file the counter.
In this matter, I am appearing for the private opposite party. I have prima facie documents to show that it's on a private land. I'll file those documents. Lordship may grant me some time.
All right. Both Mr. Mantri appearing for respondent numbers. Respondent number 1 and Mr. Ratha appearing for the private opposite parties 2 to
5, my lord. 5. The licensee OP number 5.
two private opposite parties, the licensee as well as the landowner. I have made 5 and 6. OP number 5 and 6.
OP number 5 and 6 state that they will place on record documents.
I'm appearing only for 5.
Only 5 is it? On 5.
I will file count.
Place on record affidavits along with documents, relevant documents before the next date. List on 4th January.
Obliged.
Weekly list for orders item 57.
My please, your lords. I have in 57 and 58, I already served to my learned senior the copy of the writ petition. As well, the order, your lordship, the Harismaji case, your lordship, dismissed on 7 June. Thereafter, is filed this petition filed to give benefit under the same circular. Your lordship, paragraph 7 of the same order, your lordship, direct to file representation will consider.
All right.
57 and 58, your lordship. Paragraph 7, your lordship.
The petitioner is permitted to make a comprehensive representation.
59.
Your lordship, so far as the no coercive action, your lordship, in this case, copy has not been given. Your lordship, so far as the no coercive action is concerned, Your Lordship may kindly visualize your Lordship if no correspondence but entirety your Lordship, then your Lordship
Only till your decision is taken, not indefinitely.
Your Lordship.
You're given 4 weeks time to decide, 3 months time. Sorry.
Obliged. Your Lordship.
So reproduce paras 7 to 11 of this order.
Obliged.
Basically representation. Yeah. Yeah, but this has to be now after Harishchandra Maji, what is left?
No. Your Lordship, I'm just typing what my fell from my Lord. Harishchandra Maji challenging the circular. Here, your Lordship challenging the benefit implementation of the circular. Your Lordship,
I see. All right.
59 also in view of that is.
All right. Same order.
59, 58, 57 and 59, your Lordship same. 59 is the Harishmaji order, your Lordship. Displeased to dismiss. I am the
57
dated, your Lordship.
Sir, desk. I think it's getting confusing. Which is covered by this? Whatever you handed over, what is covered by this order? Which you handed?
57 and 58, your Lordship.
57, 58. And 59 is
the Harish Maji case. Your Lordship, please to
the judgment in Harish Maji. This petition is dismissed.
Obliged.
Item number 60.
Possible.
Item 61.
Lordship, 60, serial number 60.
60. 60.
Is petitioner challenging the annexer 1, that appellate authority order, in absence of GST tribunal.
All right. Since there is no second appellate tribunal, present petition is being entertained. Notice, the access notice for the respondent's reply be filed within 4 weeks, adjourned for the next date. Subject to the petitioner, you've already deposited 10% to the.
Already put it.
Subject to the constant, the petitioner states that he's already deposited 10% at the stage of the demanded tax at the stage of the first appeal. Stop. Subject to the petitioner depositing a further 20% of the demanded tax.
Lordship, kindly allow 4 weeks time.
Yeah, within 4 weeks, no coercive steps will be taken. List on. In March.
Item 61.
Item 60. 2 weeks time to rectify defects, my lords.
All right. Defects be cured within 2 weeks. List thereafter.
Item number 62.
Respondent number 2, I am appearing for respondent number 2. One thing, my lord, we are filing that online memo by appearance, but in cause list it has not been reflected.
All right, we'll look into it.
Item 62.
So item 62, my lords, it's copy of the writ petition I have sought, my lords. So your lordship may kindly take up next week or any.
All right. At the request of Mr. Sahu, who states that he has already served a copy of the petition on the council for the state.
Yeah, it's for GST, central GST.
Central GST, my lord.
Just now I received the copy.
All right. List on 29th November.
Item 63.
Here, my lords, I've already served a copy. May I just pray, Lordship may take it up on the 29th, subject to your Lordship's kind consent.
All right. The list on 29th. At the
The
request
other
of
defect, my lord, is relating to capital letters in the Wakala. That may be ignored, my lords.
All right. Okay. Defect 14 bracket 6 be ignored.
6 I've already complied with, my lords.
Right. Defect number 6 has already been complied with.
Lordship, keep it for 29th.
29. Right.
Item 64. Item number 64.
Pass over.
Item number 65.
Pass over.
Item number 66.
Pass over.
67.
Same.
Item 68.
My lord, I've already served copies of this, my lords.
All right.
May I just place the case, my lords?
Yes, please.
But here, my lords, the petitioner has got a mine lease, my lords. And as your lordship knows, as per the mining auction rules 2015, an upfront fee has to be paid, my lords. And this upfront fee is adjusted against the royalty paid. The dispute in this case, my lord, is since your lordship knows that they are levying now GST on royalty, and since this upfront fee is being adjusted against royalty, GST has also to be paid on this upfront fees amount, my lords. And in fact, my lord, because of the COVID year, my lord, there was an extension. I paid the upfront fee in 2020 itself, my lords, after my mining lease was granted, my lords. Thereafter, my lord, nearly 1 year thereafter, they're giving me a show cause why penalty under Section 74 of the GST Act, my lord, will not be levied, my lords. On the ground that they had called in for certain information. I gave the information. I said that I've already discharged my duties and paid the GST amount along with interest. And now, my lord, this show cause notice is being used to initiate a proceeding 1 year thereafter, my lords, under section 74, my lord. And that is, my lord, annexure 7 at which is the demand come show cause notice, my lord.
We can only make the order on the show cause notice time bound. You reply to it, we'll have it time bound.
What has happened, my lord? I've already paid, my lords. And they have now, my lord, I have given a reply. They have now issuing a DRC 01, my lord. That is annexure 6. DRC 01 is a proceeding, my lord, which has begun, my lords. And it will be and this, my lord,
still annexure 6 is still a show cause notice.
No, your lordship would appreciate they have not considered my reply. They have not considered. If your lordship would kindly see, my lord, I have given my reply.
No, Mr. Kara, on this annexure 6, an order has to be passed, correct?
And my lord, this particular notice, show cause of notice, my lord, your lordship knows that the 73 and 74, they say that there has to be a determination first, my lords. Then, my lord, a demand.
No, whenever you challenge the order, that will be passed.
No, I have challenged the demand come show cause notice, my lords.
That's right. I'm saying so an order will have to be passed, right, on this?
No, since there is no determination, and because, my lord, 74 begins, if your lordship may permit me, lord, may I just place 74, my lords?
All right. Yes.
Don't worry. 73 also equal, same language, my lord. Lordship is 74, my lords. And at best, my lord, this can be a case under 73, at best, my lords, because there's no mala fide intention attached to it, my lords. 74, my lords, may I just please, my lords.
Yes.
Determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts. And there is no such, my lord, allegation.
No, there is still the stage of show cause notice. There's no,
it's a show cause come demand notice, my lord. Ultimately, my lord, if a lordship,
but you have to reply to it, then an order will be passed on it.
My lord, what has happened, my lord, now, after this, they have issued a 01, my lord, where the proceeding has initiated, my lord.
Correct.
And little realizing that it is incumbent upon them not to first determine the tax amount, which they say has not been paid or short levied, and there's a mala fide intention attached to it, my lords. Your lordship will kindly see, my lord, my payment of GST with interest, my lords. Your lordship will kindly permit me, my lord, to place that receipt, my lord, also.
No, whatever you have, you will reply. Wouldn't you reply to this 18.1?
Let's say, therefore, my lord, see the running page 103 for a moment.
But tell me one thing, Mr. Karak, this is 18.1, 18 January. We are in November.
No,
this is an 18 January. Annexure 6 is 18 January.
Yes.
We are in November.
No, they have not taken any action. They have not proceeded beyond
time bound. Said, let you tell us when you'll file the reply, or if you've already filed the reply, then we'll make it time bound.
I was only your lordship may kindly turn. No, your lordship may kindly turn.
For a moment, lordship.
Your lordship 8. Your lordship may kindly turn to page 89 for a moment, lords.
All right.
Please, for a moment, my lord. Your lordship, page 89, lords.
Yes.
This is the amount of tax paid, my lord.
Correct.
On 18/8/2020, my lord.
So you enclose all this in your reply. Let them consider it.
But it's all with them, my lords. It's all with them, my lord. Still,
Mr. Kar, if you want to file a reply, you file. Otherwise, we'll simply ask them to pass the order on this show cause notice after giving you a
learned friend, my lord. Let my learned friend take instruction, because this is a matter, my lord, which cannot stand, my lord, no legs to stand at all, my lords. Your lordship may kindly appreciate, my lords. Why should I be pushed, my lord, to a situation?
No, why can't you have an order? Which probably they'll close the show cause, they'll drop it.
This total non-application of mind, my lords.
That's right.
Because
so
once they are,
after considering your reply, they may drop the show cause.
No, once they are in season of the matter, they are aware of the fact, my lord, your lordship may see on 18/8/2020, my lord, I paid the GST amount with interest.
I'm surprised of January notice till date, nothing has happened.
No, let my learned friend at least take instructions and come back to your lordships next week or 1 week after.
Lord. That is there.
1 week after.
Page 103, that is there, my lord.
103.
103 page, lordship see, para 8. Accordingly, my lord, so and so are hereby directed so cause to the deputy commissioner.
Within 30 days.
Yes. They have to appear.
No,
that part has not even come off.
No, okay, let's go step by step. You have replied to this, you say.
No, my reply is that these materials.
No. Have you in fact replied to it or you've not?
No, my lord, after I give a reply, my lord, they have to issue a demand cum show cause notice. It can't be vice versa, my lords. They now issue a demand cum show cause notice in Annex 7. They issue me, my lord,
it is a nature of a show cause.
No, it's a DRC 01 at page 9. DRC 01 at page 6. My lord, they are compelling me to a situation which does not arise in the present case, my lords. In spite of the fact, my lord, that they're aware of the fact that this, my lord, has been paid, my lord, way back in 2020, my lords. They're issuing me on 14th of January.
No, but Mr. Karaso, I take it you have not replied to the show cause notice, correct?
No,
you have
my humble.
Not, because you would have enclosed a copy of your reply if you had.
No, I have not. I have not. I must be very frank with you, Lord.
Correct.
The reason for which I have not done it, my lord, is because, my lord, my humble submission before your lordship would be that this notice itself is without jurisdiction.
All right.
For the reason, my lord, that this 74 proceeding has been begun, my lord, without determining the tax or whatever has been willfully, my lord, withheld, my lords.
Right.
And on the face of annexure, the payments already made, my lord, 1 year back.
Yes, only show cause. You see, what is challenged in the present petition is a demand cum show cause notice dated 18 January 2022 issued to the petitioner by the Directorate General of Goods and Service Tax Intelligence, Bhubaneswar Zonal Unit, under Section 74(1) and Section 1022 of the Central GST Act 2017 and Orissa GST Act 2017, read with Section 20 of the IGST Act 2017, paragraph. Admittedly, the petitioner is yet to reply to the aforementioned notice. Full stop. It also does not appear that any final adjudication order has been passed on the said notice. Paragraph. In that view of the matter, it is directed that the petitioner will reply to the aforementioned notice, if not already done, on or before 19th December 2022. Full stop. Thereafter, the adjudicating authority will, after giving the petitioner hearing, pass an appropriate order on the said notice within a further period of 2 months thereafter. Till such time, the demand raised in the demand will not be enforced. Full stop. It is made clear that the court has not expressed any view on merits. Full stop. All the pleas of the petitioner raised in the present petition are permitted to be raised in reply to the SCN, impugned SCN.
No, demand has not yet been raised. No,
it's a demand.
It is proposed. It is proposed. Demand comes so called. Demand has not been raised.
All
yes.
All right.
I'm just trying to make an effort from it.
All right.
Item 64 to 67, I pray, my lord, next week let it come.
What's the reason, sir?
My lord, I am ill, my lord. I am not here today, and my net connection is also, my lord, poor. So let it come, my lord, next week, my lord.
Where are you, sir? You're appearing online.
My lord, my lord.
Can you switch on your camera, sir?
My lord, this is my camera is also not functioning, and that is.
We'll pass it over, sir. Just make it function. We'll pass it over.
My lord,
yes.
My lord.
Yes. Pass over.
Item number 69.
Here also. In 69, my lord, I've already served a copy on my learned friend, Mr. Satpati, my lord. Here's the challenges to
Tell me.
Here the challenges towards order, my lord, under passed under section 148D, my lords, of the Income Tax Act, my lords.
Right.
Here, my lords, your lordship would appreciate that whether without an allegation of any escapement of income, my lords, a notice, my lord, under 148AB has been issued, my lords. And your lordship would appreciate that this, if your lordship would kindly turn to page 92, my lord.
Yes.
It's 1B reason, my lord.
Yes.
The case was flagged by the system for consideration for taking action under section 147 of the Act 1961 for the assessment year 1819. as per the information, the SSE has not paid service tax, resorting to suppression of sales taxable value in the statutory ST3 taxable value of rupees so and so, in which service tax involving an amount of so and so for the assessment year 18-19. As per underlying information, the SSE Mr. so and so has escaped his return of income for the assessment year 18-19. Your Lordship would appreciate, my Lord, my very humble submission would be, how can a non-payment of tax would be an escapement of income under the Income Tax Act, my Lord, number one. Number two, my Lord, I have given my details of my gross turnover, and if your Lordship would appreciate that, page 68. My turnover...
148 AD is like a rejection of your objection, right?
And what they have done, my Lord, your Lordship would see, my Lord.
But why should one interfere at this stage also?
No, my Lord, your Lordship would appreciate now that issued me a notice for participating in 148 and 144B also, my Lord. And they have not considered, your Lordship may kindly see, my Lord, the reason, my Lord, they have given at page 164, my Lord. The submission of the SSE is not considered. My humble contention, my Lord, is 148AC, my Lord, is a mandate, my Lord, where they have to consider my objections. They can't say that I will not consider.
No, not considered meaning rejected.
No, rejected in a sense, my Lord, your Lordship would appreciate that the first, my humble submission would be, my Lord, I have not taken this to be an expenditure, my Lord. Even if I do not take this as an expenditure, my Lord, where can there be an escapement of income for the first place, my Lords? Number two, my Lords, a non-payment of tax, if at all, my Lord, under the Service Tax Act, my Lord, cannot be an escapement under the Income Tax Act, my Lord, provided I have not, I have claimed it. It's understandable. So once I've not claimed it, I give them all my reasons. After receipt of 148AB, my Lords, at least 148AC, my Lord, is incumbent upon them to consider. Your Lordship would appreciate that the languages consider the objections. And they can't just say that since such and such thing is not there, such and such thing is not there.
It's not happily worded. But when he says it's not considered, meaning is rejected. That's what it is.
And this rejection, my Lord, can't be, my Lord, at the drop of the hat, my Lord.
But it's like having so many intermediate challenges.
No, my Lord, your Lordship would
earlier GK and drive shots, that was there. That was one stage. If the objections were rejected, one did not immediately interfere.
So then may I pray, let it come tomorrow along with the other batch, my Lord, which is coming up.
I have handed over, my Lord. The Supreme Court has taken call on this issue, my Lord, and passed the order. I have handed over to 2 copies of the Supreme Court.
And thereafter, my Lord, Delhi High Court has time and again said, consistent view, my Lord, your Lordship would appreciate.
This is there. That's what I was wondering. How many intermediate challenges?
Yes, that is what the...
No, your Lordship would appreciate. In that particular case, coming from Punjab, Haryana, my Lord, no specific challenge was made to these provisions, my Lord. And your Lordship would appreciate that in this new case, in this new scheme, my Lords, they have to give me a show cause, they have to consider my show cause, and they have to pass an order, my Lord. That's a legislative language, my Lords.
They have passed an order. You're unhappy with the order, so you've come in a writ petition.
And there's no allegation, my Lord. Your Lordship would appreciate that there's no allegation of escapement, my Lord.
Correct.
May I just humbly pray, let it come up tomorrow, my Lord?
No. This is already clear.
No, let it come up tomorrow, my Lord, because, and my Lord, there are a series of judgments after this Supreme Court judgment also, my Lord.
After this judgment? Yes.
My Lord, Delhi High Court, your Lordship would kindly see.
No. Supreme Court judgment. We are on Supreme Court. Supreme Court has affirmed the Punjab and Haryana.
Okay, let me just go
through chance to
that is not cutting short.
This is not a one-line order of the Supreme Court. It's a full paragraph.
May I just go through this judgment? You come up tomorrow or day after, my Lords?
That's what, and it's not a simple dismissal. What I'm saying is it's reasoned one. Yeah.
No, may I just pray this may come up tomorrow at least.
All right. At the request of Mr. Kar. But keep this on file. List tomorrow. All right.
Much obliged.
All right.
Item 70.
May I please, Your Lordship? In this case also, I am challenging to the order passed under section 148A, subclause D of the Act.
The Supreme Court order covers it.
Lordship, 1 minute, Lordship. In this case, Your Lordships, clearly violating monetary limit, Lordships, 50 lakhs, in my cases, my Lords, alleged income, Your Lordship,
2,85,000. But section 149 1B says, my lords, if 3 years has been elapsed from the end of the relevant assessment year, then monetary limit should be more than 50 lakhs. Lords, this is my.
It's all right. It's the same. Once the Supreme Court has passed that order, you say, counsel, the petitioner seeks leave to withdraw this petition with liberty to raise all the pleas at the appropriate stage in the adjudication proceedings, in the reassessment proceedings.
Yes.
Disposed of his withdrawal with liberty is for. All right.
Sorry for the interruption. More of those matters that your lordship posed a question, whether under section 148 capital A small b, whether personal hearing is a must or not.
Correct.
So those matters have been listed tomorrow. And some are also listed day after tomorrow.
All right.
So I have got a batch tomorrow and also another batch day after tomorrow.
All right. All right.
Now I'm pitted with Mr. Chimaka.
He's sitting right behind you.
Yes, this Banvas.
Yes.
Item 71. Item number 71.
70, I am appearing for the department.
Mr. Kare, it's your matter, I think. No?
My lords, I will remove the defect in this week.
I see.
May call the matter next week.
All right. Defects we removed within a week. List thereafter. All right.
Obligation.
Item number 73.
Haryana. What is Haryana?
Yes, your lordship may kindly turn to annexure 1 at page 22, Milos. It's an audit objection report, Milos, and the report starts at the next page at page 23. This is your lordship, it starts with, it's a draft audit report under section 65 of the OGST/CGST Act, Milos, in favor of the petitioner, Milos. And 2-3 dates I am bringing lordship notice at the top, Milos. Date of issue of audit notice 28/4/2021, date on which audit undertaken 8/10/2021, date of raising of revenue paras 31/5/22, Milos. It's a draft report under section 65. Then I am taking your lordship's attention to annexure 2. And before that, this at page 41, at the end of this report.
1 minute. The cost title, I don't know why they put Haryana. Company's name is Simon India Limited. It may be
Simon India, yes. No, branch is at Bhubaneswar. It's your lordship jurisdiction only. The report ends at page 41. Your lordship may kindly see. The date of the draft report is 30th June 2022. Your lordship, find that? Page 41.
Doesn't mean that cost title should be that comma Haryana.
Page 41, the end of the report, Millards.
Yes.
The date is 36/2022, draft report date, Millards.
Right.
And the next page, you may kindly see annexure 2.
Yes.
GST edit 2. Yes. Audit report under section 65(6). This is dated 36/2022. 65(6). And at the end, your lordship may kindly see you are directed to discharge your statutory liability in this regard, as per the provisions of Act and rules made thereunder, failing which proceedings as deemed fit may be means 73 proceeding. Now, I will only take your lordship attention to provision 65. Section 6. I have quoted in the petition itself. That your lordship will find from page 9.
No, why should we entertain a challenge to a draft audit report?
Exactly, Milord. Milord, what I am trying to pursue, lordship, Milords, 65(4) and 65(6) cannot survive together, Milords. You can't issue draft audit report and final audit report on the same day. Milords, there is a specific rule.
And as a result of this final audit report, what is happening? Demand is raised.
No. The procedure which is supposed to be followed under section 101 rule. My lords may kindly see for only 101 rule, Milords. Rule 4, sub-rule 4.
OGST rules, is it?
My lords, GST rules.
101.
101, rule 4. Sub-rule 4.
Yes.
The proper officer may inform the registered person of the discrepancies noticed, if any, as observed in the audit, and the said person may file his reply, and the proper officer shall finalize the findings of the audit after due consideration of the reply furnished. Because it's a draft audit. Audit has not yet been finalized. But annexure 2 says, if we will not discharge your liability, then we will initiate proceeding under section 73. It hints upon 73. My humble submission is 141(4) is mandated to be complied with, saying that, Millards, I have to file a reply. Millards, any other accounts, documents which I rely upon has to produce, Millards.
What did you do in the last 5 months? This is 30th June. What happened?
Plus, matter is pending, my lords, still pending. All the documents, records are with me.
No,
I
they
have
have not gone for the 73 proceedings yet.
No, they have not gone, but they have to, before going to 73, they have to comply 1014 bills. They have to comply 1014 bills.
No, but have you replied to that 101?
No, they have not sought for reply. That is my humble submission. But they have to seek a reply, seeking information. But I have to comply that, and thereafter they have to conclude the audit.
No, once you got this on 30th June,
my lords,
you should have treated this as under 101, rule 101. You should have filed a reply.
Yes, thereafter immediately I have approached your lordship and informed them that writ petition I have filed, matter is pending. They are also kept the proceeding pending. They have not finalized audit. My only submission is, lords, if your lordship will say section 65, your lordship, because across the country, lords, this question is still left unanswered. I was checking up everywhere, lords, that nobody has answered yet. 65, your lordship, kindly see the provision. Very important, lords. Only 2 subsections I will bring lordship notice. Kindly see 65(4), lords. Page 10 of the writ petition.
All right.
These are mandatory things to be followed, lords. They has not been followed. The audit under subsection 1 shall be completed within a period of 3 months from the date of commencement of the audit, provided that where the commissioner is satisfied that audit in respect of such registered person cannot be completed within 3 months, he may, for the reasons to be recorded in writing.
We don't know what they've done after that.
Your Lordship,
After 30th June, you've done nothing.
That part I have to take instruction. Your Lordship, so far as the
How can it be the same day? You can't give a draft audit report on 30th June, pass the final audit report on 30th June. What does that mean?
Your Lordship, so your Lordship, this draft audit report has been passed, your Lordship, on that day. Your Lordship, that is 30th/6. 30th/6, the draft audit report has been passed. And this audit, so far as the limitation point is concerned, this notice have been complied on 22nd March 2022. And after that, also notice has been issued, which has not been complied, your Lordship.
No, where is 22nd March? Where do you get 22nd March?
Your Lordship, at page 24.
24?
Page 24. Your Lordship, page 24, while a person, and your Lordship, at the first paragraph, he did not reply to the intimations after 22nd March 2022.
No, this is not the draft audit report.
No, draft audit report, your Lordship, has passed on 30th June. That is that
so
is where,
101.4, come to 101.4.
Your Lordship.
Rule 101.4.
Your Lordship, so far as the 65(6), so far as the provision of sections,
come to 101.4 first.
Your Lordship, 101.4. Your Lordship, 101.4, that the proper officer may inform the registered person of the discrepancy noticed, if any, as observed in the audit, and the said person may file his reply, and the proper officer shall finalize the finding of audit after due consideration of the reply furnished.
So where has this been complied with?
Your Lordship, that part.
In the same day. In fact, both order, the final audit report and the draft audit report are dated the same date. How can it be?
Your Lordship, may kindly turn to 65(6). Within a month, that is, on conclusion of audit.
The same day. The draft audit report and the final audit report are dated the same day. 30th June of the reply. Yeah, that's right.
Your Lordship, 30th June, that is right.
So we'll relegate it to the 30th June. Let him file a reply now within 30 days.
Yes.
Then you finalize the audit report.
Let's see, your Lordship is absolutely right. But whether this audit observation report, (65)(6) should have been passed within a month.
The limitation has set in.
Within 30 days, correct. 30 days, your Lordship is correct. Limitation also I have challenged. Your Lordship is correct. 65(6) only 30 days. Nothing has been done in 30 days.
When was the audit undertaken?
That your Lordship will find from page 23.
Your Lordship,
sometime in March.
Page 23, date of issue of notice 28/4/21, date of audit undertaken on 8/10/2021.
8/10/21.
21.
Your Lordship, that is justified. Why, your Lordship? Whichever is latter, the date of compliance or the date of order. Your Lordship, that is in the explanation. Explanation of 65(4).
Explanation said when the accounts are produced 30 days from thereafter.
The purpose of this subsection.
All right. Produced it in March.
Your Lordship.
When did he produce
Your Lordship, it has been produced on 22nd March 2022.
So 30 days starts running.
No, not 30 days.
Yes. Explanation says
No. Not 30. Your Lordship, again 65-4. 3 months. 3 months, Your Lordship.
Within 30 days.
3 months, Your Lordship.
Even 3 months, you're out.
3 months also out.
3 months, Your Lordship, why I'm saying that is justified. 22nd March 2022, he has complied. Again, Your Lordship, notice have been issued, which has been non-compliant. Your Lordship, that is at what I have placed. He did not reply to the intimations after 22nd March 2022. Thereby, I am constrained. The draft audit report has been passed on 30th June 2022, only 6 days delay. Your Lordship, that part, Your Lordship, because consequential also we are waiting for any compliance. Assessing officer, audit officer is waiting. For that 3 months is there and 3 months has been complied. So only so far as the 65-4 and 65-6, that 1 month, Your Lordship, there might be some lacuna.
Lacuna means nothing is there.
There's no provision for extending the time. That you have not gone by. That proviso to 65-4.
Your Lordship.
Extension, not short.
Not extension.
So 3 months is
3 months. 3 months.
Over on 22nd March. June.
No.
Your Lordship, judgment is there.
3 months, Your Lordship, I may be permitted to place. The audit under subsection 1 shall be completed within a period of 3 months from the date of commencement of the audit. Now, Your Lordship, the proviso is not required. Explanation. For the purposes of this subsection, the expression commencement of audit shall mean the date on which the records and other documents called for by the tax authorities are made available by the registered person or the actual institution of audit at the place of business, whichever is latter, Your Lordship. So that means the limitation in OST case will commence from 22nd March 2022. Yes. Here, the audit report is to be supposed to be passed by 22nd June 2022, Your Lordship. Now, Your Lordship, prima facie on the face of this, because I don't have any instruction, after 22nd March 2022, also notices have been issued to the petitioner. From that, it can be presumed, Your Lordship, because the record is not with me. Because he did not reply to the intimation after 22nd March 2022. That means a notice has been issued which has not been complied with. Hence, Your Lordship, my respectful submission, so far as that limitation of 3 months, strict interpretation may not be. Your Lordship, because I don't have the record, I may be called for the record. Your Lordship, whether any notice has been issued or not. Or Your Lordship, so far as this 65-4 and 65-6, so far as both the date, Your Lordship may set aside the matter to the audit officer for.
I think it's better you reply to the draft objection. You can take in that reply that this is time barred.
Reply along with the documents and accounts, whatever I have support of my reply.
Yes. But Your Lordship, since 1 month limitation is there from 65-4 to 65, I pray let the petitioner may cooperate and submit.
We will cooperate, but there is no extension on the side of the department. That's the whole difficulty. They could have taken an extension and commission has the power to grant extension also, which they have not sought for. And last line, what my friend was submitting, it is mentioned on 22/3.
Yeah, you have to apply. Yeah. So how do you get over that? You have to complete within the six months period.
One order I have given to Lordship. That is of course on a VAT. 41-4 minors.
Correct.
Matter is before the Honorable Apex Court.
41-4.
Yes, sir. Apex Court has referred to larger bench. This matter.
7 days.
No.
9. I think
Your Lordship, in that case, that PAL construction, Your Lordship, my Lord has observed that that 41-4 has not been. There is no conflicting judgment.
Right.
Only one judgment was there. So that reference has been disposed of.
No, thereafter, Shreyan's case, I think they have been referred to larger bench in Supreme Court. I feel. I'm not sure. Shreyan's case, which was Shreyan's
matter has been gone to Honorable Supreme Court. Your Lordship, in that 40-6 limitation period, Your Lordship might have remembered,
your Lordship has said that the extension is to be applied before completion of that 6 months.
Correct.
That matter, the department has gone to Honorable Supreme Court. And Honorable Supreme Court, since in the Shreyans matter, your Lordship has quoted the Shreyans case, and Shreyans matter has been passed by a 3-judge bench. So this matter has been left to a larger bench, your Lordship, and that is pending before larger bench. So far as the limitation is concerned.
But here, how do you get over this? Even if you give them time to file reply and for you to pass an order, the 6 months period also, you've not actually applied for extension. Unless you've applied for extension, how do we get over that?
Correct.
Because the draft order, the draft notice, the draft order seems to have been passed within that period of 3 months. Your Lordship, what my submission on 22nd March.
It's actually not even within 3 months, because from 22nd March it's 30th June.
only 8 days delay.
It's better you undertake a fresh audit. I think too many problems you have.
and also only difficulty is that your Lordship, I can understand. Only difficulty is that 65.4 and 65.6. That should be 1 month. Within 1 month after this draft order.
Correct.
That 1 month has not been complied.
Because they were running as it is beyond 3 months, they decided to do both the same day.
So, your Lordship, I think it can be, your Lordship can pass, your Lordship can direct the petitioner to comply with...
No, but how do you get over the 6 months limitation?
Correct.
6 months you have to, it cannot exceed a further period, not exceeding 6 months.
And the extension has to be reasoned record in writing mirrors. The language is the commissioner has to...
one way of reading it is 3 months plus 6 months.
3 months plus 6 months.
By a further period not exceeding 6 months. Just see the proviso. He may, for reasons to be recorded in writing, extend the period by a further period.
3 months plus 6 months.
So then he may...
But reason to be recorded in writing by the commissioner.
So in the meanwhile, then you have to do this. So we will give a time-bound direction, provided you apply for and get the extension done in terms of the proviso.
They have not done, they could have done, but they may not.
Your Lordship may
You'll have to do it. You'll have to do it. Otherwise, even the final audit report will go out of the business. So you're already crossed the... No, they'll have to apply for the terms to You see, notice, he accepts notice. The challenge in the present petition is to both a draft audit report dated 30th June 2022, issued by the head of the audit team -1 CT and GST circle, CU2 Katak, as well as the final audit report of the same date issued under section 65(6) of the Orissa GST Act 2017 OGST Act. Paragraph. Mr. Jagvindra Sahul and senior counsel appearing for the petitioner at the outset draws attention to Rule 101, (4) of the OGST Rules 2017, which reads as under, reproduce 101(4). He points out that in the present case, there was no opportunity granted to the petitioner to file a reply to the draft audit report. And paradoxically, on the same day that the draft audit report was issued, the final audit report was also issued. Paragraph. Secondly, he points out that under section 65(4) of the OGST Act, the audit under 65(1) thereof had to be completed, open quotation, within a period of 3 months from the date of commencement of the audit, unquote. In terms of the proviso to section 65(4), where the commissioner is satisfied that the audit cannot be completed within 3 months, then, open quotation, for reasons to be recorded in writing, unquote, he may extend the period for completion of the audit, open quotation, by a further period not exceeding 6 months, unquote. Paragraph. In the present case, admittedly, the audit exercise commenced on 8th October 2021.
But 3 months to be reckoned from 22/3/2022.
Yeah, but 3-month period was commenced on 22nd March 2022, when the petitioner is stated to have submitted the documents called for by the authorities. Full stop. At this stage, it is necessary to refer to section 65(4) and section 65(6), which read as undertake the whole thing. Paragraph. In view of the explanation to section 65(4), the 3-month period within which the audit had to be completed commenced on 22nd March 2022 in the present case. Full stop. In other words, the entire audit exercise had to be completed with the submission of the final audit report in terms of section 65(6) of the OGST Act on or before 22nd June 2022. Paragraph. Perhaps with a view to meeting this said deadline, and knowing that the deadline of 3-month period had already been crossed, the authorities issued both the draft audit report as well as the final audit report on the same day, that is 30th June 2022. Paragraph. On the plain reading of section 65(4) together with 65(6) and rule 101(4) of the OGST rules, it is plain that the procedural requirement of the petitioner having to be given 30 days time to file a reply to the draft audit report was not followed in the present case. So on that short ground, this court sets aside the final audit report dated 30th June 2022, issued under section 65(6) of the OGST Act. Paragraph. The position would therefore revert to the stage at which the draft audit report was issued on 30th June 2022. Stop. However, for even this draft audit report, even if the petitioner is afforded an opportunity at this stage to file a reply to the above draft audit report, which is a 30-day time, and thereafter for the authorities to issue the final audit report, the original deadline of 3 months would well be crossed. Full stop. That would render the entire exercise futile. Full stop. Therefore, the following directions are being issued by this court, subject to the condition that the commissioner will, by a reasoned order, in terms of the proviso to section 65(4) of the OGST Act, extend the time for completion of the audit by a further period as he considers necessary, but not exceeding the further period of 6 months in terms of the said proviso. Paragraph. It is accordingly directed as under 1. The petitioner will file its reply to the draft audit report not later than 19 December 2022.
Kindly mention along with supported accounts and documents.
Yeah, accompanied by all the documents that the petitioner wishes to rely on. After considering the reply of the petitioner, the final audit report will be issued under section 65(6) of the OGST Act within a further period of 30 days, and in any event not later than January 20th, 2023. What were you saying?
Your Lordship, then Your Lordship, that 9 months, 6 plus 9 months will exceed to 3 months. If 30th June or 22nd June, Your Lordship, if December 19th December, you will file and another 1 month, Your Lordship, then that in total 9 months.
That will again get crossed.
December. 22 December is the last, even if 9 months is taken into account.
So my Lord, my Lord and Senior has prepared everything and he can file within this month.
So, and that is always again subject to commissioners giving extension in writing, recording reason.
That your lordship knows that can be done.
So let him file his reply. On a say 26th November. No, 28th November. 28th November. And for the final audit report to be filed on or before 19th December. Not 20th, no, 21st, is it? 21st December 2022. Paragraph, it is reiterated that the above directions will be subject to the Commissioner granting extension of time in terms of the proviso to section 65(4) of the OGST Act. Full stop. In other words, if such extension is not granted, then even the draft audit report bracket annexure 1 would stand automatically quashed.
1 and 2 years.
No, 2 is already quashed.
Your lordship, the date on which the petition is
28th November.
28th November.
So you have time from 28th November to 21st December.
Your lordship.
All right.
Item number 74.
May it please your lordship.
So bless you.
May it please your lordship.
Yes, please.
This petition was filed by SR Steel Limited, my lords.
Which no longer is there, is it?
No longer is there. It has been purchased lock, stock and barrel by Arsenal, Lakshmi, Arsenal Metal and Nippon Group. And I am filing an application, a short amendment application, substituting the name of SR Steel from SR Steel.
It doesn't seem to be so short. It doesn't seem to be so short.
Unless resort, money will not come in that way.
2015 notification has been challenged.
Wow.
But the name has to be substituted. I have given that.
So we allow this application.
Yes.
Yeah. This I-8 to be numbered, you say. This is an application for substitution of the petitioner with the entity that has taken it over, namely ArcelorMittal Nippon Steel India Limited. Full stop. There is no objection to this said application being allowed. So accordingly,
I'll file the consolidated application by Monday.
And the petition is substituted by ArcelorMittal Nippon Steel India Limited. The consolidated cost title be filed within 1 week.
Within one.
Consolidated copy may be solved. Consolidated copy may be solved.
Yes, of course. Lordship may fix a date for
28th February.
28th of
February.
November.
February. Item 75.
Possible.
Item number 76.
75 is infructuous.
I see.
That is why they are not coming. Because after 31st March, this application has become inactive. And they have filed it on 28th March. For the first time, it is listed now. But
anyway, we'll just pass it over.
Yes.
All right.
Yes, madam. I'm sorry.
Item number 76.
76, 77, same things.
Same, Your Lordship. As of 32, no, Your Lordship. As of 32, item 32, seeking waiver of liability of Your Lordship.
Same notice. When is that coming up?
16th of February, Your Lordship.
16th February. All right. He accepts notice. Reply within 4 weeks. All right.
Item 78.
I have filed for restoration, my lord.
2008.
My
No, what's the point, sir?
lord.
What is the point? 14 years later, we're restoring a writ petition,
My lord,
which
due
was
to the-
dismissed when? When was the writ petition dismissed?
My lord, due to the fault of the conducting council.
No, when was the writ petition dismissed? In 2008, 22nd January 2008. senior to the opposite party, seniority dispute. There's no point now. You see, the present application seeking restoration of writ petition of 2000, which was dismissed for non-prosecution in 2008, has not even been listed once in the last 14 years. Full stop. The dispute being one of seniority clearly has been rendered infructuous due to passage of time. Consequently, the court is not inclined to interfere. The application is dismissed.
Item number 79.
None appears. Oh, you're there.
Yes, my lord. My lord, in this case, on 7/4/2012, my lord, there was a racial discrimination. The petitioner are victim of racial discrimination, as a result of which.
Was there an FIR filed, sir?
My lord,
an FIR has been lodged or not?
Yes.
What is the progress in that FIR? What is the progress in that FIR?
FIR, my lord, now its trial is going on, my lord.
So let the trial be concluded and then you file a representation. Depending on the outcome of the trial, sir.
As per Annexure 6, Ministry of Social Justice.
They're all SCs,
empowerment.
All the petitioners are SCs.
Yes, my lord, one family, my lord.
I see. Why don't you take instructions, Mr. Monty, then?
My lord, collector has filed an affidavit that is available on record. That is on 6th December 2013. Collector Malangir. Achi na? Achi?
No.
Copy diya hai.
Yeah, you also filed rejoinder.
My lord,
rejoinder he has filed.
I have filed rejoinder and the petitioner
on
filed
5th November 2000.
One of the chart also, what they receive or what they not received. A detail I have filed.
You will file?
Yes, my lord.
Rejoinder has been filed on 5th November 2014.
No, but he says he'll file a chart. You've already filed or you will file?
I have already been filed.
He's filed an additional document. Have you seen that?
And already one copy I have served to government advocate. Accordingly, maybe disposed as per my chart.
Disposed of?
As per my chart. What the petitioner last date, my lord, this honorable court passed the order, directed me, Mr. Counsel, what till date, what you have received the compensation, what you have not received.
Right.
Detail you file a chart.
Yes.
Therefore, I have been filed, my lord.
All right. You say Mr. Monty states that the chart presented by the petitioner, you have it, Mr. Monty?
May I request him to provide a chart because
I have already been provided, but again I will provide.
Okay.
All right. Another copy of the chart submitted by the petitioner.
It is not there.
Showing what is the amount still to be received by the petitioners. Be provided to Mr. P.K. Mantri, learned AGA, during the course of the day to enable him to seek instructions. List on. December 9th. Not 9th, sorry, 19th December. Can't have it. Yeah.
9th December.
Yeah.
Well, that prisons matter was at 2 p.m. So can I pray for a short? In fact, there are two bottlenecks. If your lordships would allow, two bottlenecks are there. One is regarding this police housing corporation. They are.
Mr. Sabra is there.
That's right.
There, the capacity expansion isn't happening in the jails, which are actually overcrowded, like Jajpur and Bhadrak. So the overcrowding is just trying to go up.
Right.
So I had two requests.
Yes.
One is that if the MD, State Police Housing Corporation,
yes,
he can be requested to remain virtually present to assist this court.
Right.
Because that is one major bottleneck. The other one, I think Mr. Chabra, he's online. He may also put in his inputs. This health department, psychiatrist there is no movement.
Is there anything tomorrow?
No, it can be taken up tomorrow.
2 o'clock. Mr. Chabra, we have a reference today at 2 o'clock. So we'll take it up tomorrow at 2 o'clock.
Sir, as per your convenience, sir, we are ready with our information.
All right. You just note an affidavit has been filed on behalf of by the Deputy Inspector General of Prisons on 7th November 2022, which is placed on record. Paragraph. Since there is a reference, full court reference at 2 p.m. today, list tomorrow at 2 p.m. All right.
We are grateful.
Item number 81.
May please your lordship. This is PIL matter, my lord. Matter relates to installation of CCTV camera and firefighting instrument in SB Medical College and Hospital, Cuttack, my lord. This matter appears today's list as per order number 4, dated 1st August 2022. I would like to place the said order if your lordship permits, my lord. Order dated 1st August, my lord.
No, have they filed a reply?
No, I have not received, my lord.
So you have to file a reply, Mr. Monty. Mr. Monty seeks and is granted a final opportunity to file a reply, to file an affidavit in relation to the, in terms of the order dated 1st August 2022, within 6 weeks. That's all.
I have got small submission to be made, my lord.
4th January.
I have got small submission to made if your lordship permits only. Only because what happened, the patient of SB Medical College is now, their life is in danger. Only because low and poor quality of saline has been supplied, my lord. That has also been tested by the medical authority, and it is found that the very poor quality of saline has been supplied to them. And most of the patients are also fell ill, my lord. That has also been reported. So my submission before your lordship is that now the poor quality of medicine has been supplied. The crime branch is investigating. So I want to only to place, and they have to give reply to that, my lord. The saline which has been supplied and consumed poor quality, many patients are falling ill, my lord. I only, if your lordship permits, I'll only place that document and copy of the same.
File an IA, sir, a proper IA, not just like press clippings. File an IA, sir.
I will file an affidavit.
An application and whatever you want directions, because this issue, main issue is something else. Yes.
Item number 82.
Please, your lordship. As per your lordship's last order, second paragraph, the state was to file affidavit indicating.
Affidavit is already filed, but I cannot serve the copy to my learned friend.
All right. The affidavit of the state be served on counsel of the petitioner during the course of the day.
You ask your junior to collect it.
I'll collect it.
List on. December 21st December.
Yes.
Item number 83.
Item 83, your lordship, I filed my rejoinder today. I've also served copies before the Union of India.
I don't think it's come on record. Look, the rejoinder of the petitioner be placed on record.
We didn't receive the copy of this MS.
All right. List on 3rd January.
Obliged.
List item 84. 3rd January. Item 84.
Your Lordship, I am appearing online.
Yes.
Your Lordship, this writ petition has been filed for challenging Section 141 of the CGST Act, through which amendments have been made in 2018, that we cannot transition the education cess and higher education cess. In relation to this, we were also issued a show cause notice by the jurisdictional officer on 12th March 2021. We had requested that the adjudication.
The Supreme Court matter is still pending, is it?
Yes.
Yes. All right. It is stated that the matter in the Supreme Court is still pending. Interim order to continue.
Just one request, Your Lordship, one request. There is an order which has been passed by the jurisdictional officer. They filed a show cause notice We told them to wait, that the writ petition is still pending before your lordship, and hence the matter should not be decided. However, they've given us an order asking for us to pay the demand of the transitional cess of 13 crores. So we have filed an application for amendment, if you can allow that, your lordship.
All right.
Interim application number 14639 of 2022.
All right. 14639 of 2022.
First case.
For the reasons stated therein, the application is allowed. And the
filed consolidated
writ petition is permitted to be amended as prayed for. The consolidated writ petition be now filed within a week. What is this 14640?
Your lordship, we are asking for a stay on the execution of
In 14640, you say till the next date, no coercive steps shall be taken against the petitioner pursuant to the order dated 31st August 2022. List on. February 13th.
Oblige, your lordship.
Your lordship, third sub-item, interim order to continue.
Yeah, all right. In all other matters that interim order.
Obliged.
Item number 85. Item number 85.
Also,
item number 86.
Not 86, I have highly small reply to the rejoinder. Kindly relance.
I'll take time, my lord. Today they solve a copy, so 2 weeks time to go through that reply.
All right.
If necessary,
filed to the rejoinder, constituted petition seeks time to examine it. This on 13th February, 1-3.
Item number 86, 87.
Item 87, lordship, I have not received the counter filed by the open.
What's the matter about?
Matter relating to the petitioner seeking compensation from the opposite party number 1 on the ground that due to the negligent act of the opposite parties,
they have filed counter.
But I have not received the counter.
Copy of the counter affidavit filed by opposite parties 2 and 3 be served on counsel for the petitioner today within 3 days. Rejoinder that to be filed before the next date.
My lord, we have filed a compliance affidavit, that Junagadh case. Yes, your lordship has directed, and we have filed a compliance affidavit. That copy has already been served on them.
But as per the noting, I have not received also. There is a noting also, lordship.
Okay, will. That is a compliance affidavit dated 8th September 2022.
22?
Yes, my lord. Recently we have filed that.
Oh, no, that's not come on record.
Yes, that is filed through email mode on 8th September 2022. 8th September.
Oh, you say an affidavit dated
perhaps that
8th
is
September 2022 has been filed.
I have not received.
On behalf of the government.
This is only the status of the criminal case.
Yes, that is by order dated 4th July 2022. Your lordship has directed that this present status of the Junagadh PS case
So
number.
he's got acquitted.
They got acquitted.
It's ended in an acquittal. So what happens to the compensation then? Have you received the counter affidavit filed earlier?
I have not received the counter affidavit.
Or that will remain then. You say in addition to the above, an affidavit has been filed by opposite party number 4.
On 25th 11/2024.
Dated 8 September 2022. Stating that the criminal case has ended in an acquittal. Copy of this affidavit also be served on counsel of the petitioner. List on. January 2023.
Pardon, my lord, when it will be posted?
17th January. Item 88.
Item number 88, there are 2 matters. Lordship will find in the first matter, state has filed counter. Second matter, state has not filed counter. If they will not opt to file any counter, then I can plead the matter before your lordship. Second counter
I think both the matters are identical.
Both the matters are common. Points will be common.
Identical matters.
Demand of the year, I mean dues of the year 89, they are giving notice in the year 2021. But the intervening situation here is, my lord, lordship will appreciate Noxalites, they in the red zone, these shops are there. Noxalites forcibly burnt these shops and closed down these shops. As a result thereof, the shops were admitted, my lord. And Commissioner of Excise has recommended waiver of fees and entire thing to the government. So all those recommendations in my second matter, your lordship will find those specific orders are there. Kindly see those recommendations. Commissioner of Excise, page 39, your lordship would kindly turn to. In the second matter, my lord. Kindly see.
I think I have explained everything what he has alleged in the writ petition, and he has to file rejoinder because there are many factual things which I have stated in my written statement.
Lord, I can file a rejoinder, but
if you will not file count rejoinder, then all these allegations
I can assist your lordship, but then I'll definitely file it. Good for me.
All right.
Filing of a rejoinder is good for me.
If you are filing rejoinder,
Mr. Mohanty states at the outset that the counter affidavit already filed in writ petition civil 8073 of 2022 will be adopted in writ petition civil 7635 2022 as well. Rejoinder now be filed before the next date. List on 9th February.
But should I request for interim order to continue, my lord?
Interim order to continue. Reply not filed.
My lords, here the matter has initially there was a demand of 91 lakhs against the petitioner, my lords. And thereafter it has been reduced to, we made a representation. This is reflected in your lordship's order.
Yeah, 27 lakh 39,000.
11/8/22. It has been reduced to 27 lakhs 39,453, which we have already paid. We are running the institution. I mean the
there is an order 11th August. I think my friend has complied it.
So we have complied with the
interim order.
Interim order with the demand that was raised upon us. We have paid that.
If they have complied with it,
and it's a
let
revised.
him approach the excise commissioner. He will take.
We are already operating. We are going on operating. Your lordships can note my submission and
all right. So far as the balance amount is concerned,
that has already been reduced.
Yes. So the matter has become in progress.
Yes. In terms of the order dated 11th August 2022, the revised reduced demand has already been deposited by the petitioner. Full stop. In terms of that order, the competent authority was to consider the renewal application of the petitioner. Full stop. No further directions are called for. The petition is disposed of.
Malus. Your lordships may note that we are running the unit.
Yeah, correct.
Deeply obliged.
Wait, please, your lordship. Your lordship, the present petitioners have approached this honorable court against the diversion of the funds allotted to the District Mineral Foundation Sukinda block to the district headquarter hospital that is being constructed in Jajpur, your lordship. On 29/6/2018, the opposite parties had been directed to file a counter on the same, your lordship. But till date, we have not received any counter.
But this diversion of funds and all, you can go to the Lokayukt.
Your lordship,
these are matters for the Lokayukt.
Your lordship, but there is no allegation of corruption as such. There is the decisions that have been taken by the opposite parties. We are challenging those decisions because they violate the District Mineral Foundation rules and the PMKKY rules, your lordship.
No, you don't want them to spend it for construction of a hospital.
Your lordship, we our grievance is that also the rules also specify that if we fall under a directly affected area, your lordship, the District Mineral Foundation funds are to be invested only in those particular area, your lordships.
No, but why not for a hospital?
Your lordship, and in Sukinda, which is a directly affected area, there is no healthcare facilities as such except one community health center, your lordship.
All right. You say a reply be filed to the petition as a last opportunity within 4 weeks, rejoinder for the next date. This on 17 January. All right.
Much obliged.
Weekly list passed on matter item number 20.
Made to the last. Ballot by C. Miller's last order dated 16/9/2022. Miller. Paragraph 9 and 10. That is relevant. Where consequently, direction is hereby issued to AIMS Bhubaneswar to provide treatment to the 15 children whose names are set out in the writ petition, and cost of such treatment shall be reimbursed by the Government of India in the Department of Health and Family Welfare. A direction is issued to the Director of AIMS Bhubaneswar to draw a schedule for consultation with the said 15 children suffering from DMD with a specialist in AIMS Bhubaneswar for the purpose of receiving AON therapy in a time-bound manner. This be done in consultation with Mr. Padhi, running ASGI, as well as Mr. So-and-so for the petitioner, and the affidavit of compliance be placed before the court on the next date. On the date fixed, that is the 11th October, they took time, my lord. And my lord, as per my information, this 15...
My lord. May I interrupt, my lord? My lord, today we are filing an affidavit of the Government of India. Mr. Guchayat will hand over the copy of the same to my learned senior. And the copy also served to the court. So today we are filing, we are ready with this affidavit. In this affidavit, we have elaborated everything. My learned senior will go through it. Then it is appropriate to talk of the matter any day, then can be here.
All right. In the month of 16. Well, let me take up to 16. My instruction is, well, at least all 15 children that they are called, prescription has been given, but no steps has been taken with regards to their treatment.
With regard to the treatment is concerned, there is 4 M's. See, 3 numbers of M's there. There is some facility giving such type of treatment. We are giving treatment, but there is a different type of indication, or let's say it is a patients are coming, they require a different treatment, a different what my learned friend is submitting before my lord. It is a completely separate status of treatment, you can say, and that too, there's medicine what they are prescribing now. It is in US and it is under the process, my lord. It is we will not come to the final stage. Anyway, which can be counter affidavit has been filed by the Undersecretary in the Department of Health, is it?
Yes.
Yes, no, Department of Health. Ministry of Health and Family Welfare, Government of India. A copy which has been handed out to counsel the petitioners. A rejoinder that too can be filed for the next date. Yes, madam. The interim orders already passed are continued. In the meanwhile, list on 1st February.
1st February?
Let the treatment continue.
With regard to treatment of the children.
That's right. Let it continue.
No treatment has been given. No treatment has been given. Only they have my instruction is no. It's a party. I have talked with the parents. I have talked to the parents. They said we are consulted. A prescription has been given. Not a single treatment has been given, provided.
But this is a peculiar status of disease, my lord.
Peculiar status of disease, but we have not provided a single medicine. Nothing.
It not can be given everywhere in every manner.
My lord may take up this matter.
Not be given in the patients now.
My lord may take up this matter on 23rd. I will give a detailed information. I will give the detailed information, my lord, on that day. Again now, replying to the affidavit filed by them.
24th. We'll take it on 24th. All right. List on 24th. 24th this month, my lord? Yes.
Yes.
Item number 64. Item 64.
My lord, item 64 and 65 and 66, my lord. I pray, my lord, let it come, my lord, next week. I will prepare on this matter, my lord, because it takes some time, my lord.
Is coming after notice of
this is with regard to, my lord, imposition of penalty.
Yeah.
All right, at the request of counsel to petitioner. January.
Item 64, 65, 66 and 67.
67, my lord.
Last one matter, item number 75.
None appears despite the pass. Dismissed.
Item number 85.
85 minutes on the last two occasions also no one appeared on behalf of.
None appears despite the pass. Dismissed. Over. Okay.
Appeared in this case, my lord.
Which one?
On 4/11/2022 for respondent number 2.
The settlement has not been directed?
No, my lord, this is a case of nil award. They haven't exhibited anything, any documents. They haven't exhibited any documents before the lower court.
No, so not settled.
No, it's not possible.
All right.
My request, my lord, if a lordship will send it to the
bench.
permanent local adalat.
No, it cannot be
already
settled.
done.
Already. Yeah, lordship was directed really.
You see, no settlement has been possible before the PNCLA. Let's go for the roster bench on 2nd January.
My lord.
Item 2 also. Second case, same.
Second case also same. My lord, I have my name may be reflected. I have filed the wakalatnama.
All right. Just put it. All right.
Thank you.